Committees on Public Safety to hear the Firearms and Ammunition Sales Initiative. First, I want to welcome everybody to the joint hearing by the Committees on Public Safety. This year's proposed initiative on firearms and ammunition sales, I think we'll have quite a enthusiastic discussion on this. The purpose of this hearing really is to educate ourselves and the public as to the specifics of the ballot initiative, and to provide a forum for public participation, which is probably the most important part for us, not only on the committee, but for the general public. I recognize that anything that deals with firearms can be very divisive and often a very, very emotional issue. I just want to remind everyone to be respectful of divergent points of view. Everyone's view will be respected, and I can assure you that both on the Senate side and the Assembly side, all information that is heard today will be given the full magnitude of consideration as we move forward. While our respective committees have already examined many of the issues that will be brought forth by this proposed initiative in the form of prior legislation, I look forward to hearing testimony from both sides, as well as the findings from the Legislative Analyst's Office and comments from the public. I also wanted to thank the members of the Public Safety Committees who have spent hours and hours and days preparing us for this time, and for taking the time to participate in this informational hearing. And with that, I will give it over to my colleague, Lonnie Hancock, Chair of the Senate Committee on Public Safety, and I like to say all the time, my partner in crime.
Yes, we do that quite a lot, actually. Thank you, Reggie, Assemblyman Jones Sawyer, and we are all looking forward to what we're going to find out at the hearing today. We know that the Elections Code specifically calls for a hearing, an informational hearing. No action will be taken today on what is in the initiative. We have no authority to alter the initiative measure or prevent it from appearing on the ballot. This is just to make sure that we all can thoroughly discuss the provisions that are in it. As Assemblyman Jones Sawyer said, this ballot measure addresses a very, very serious public issue with great implications for the safety of all the communities in California. So we look forward to what we're going to learn today. And are there other members of the committees that would like to make a comment before we begin? Assemblyman Quirk?
For the people who are testifying today, thank you very much for being here. Really appreciate your taking your time to do this. And to the chairs, thank you very much for holding this hearing. I very much appreciate the time you've put in, as well as that the staff has put in preparing for this. My concern for the people who are testifying deals with increased cost to the state for regulation, for courts and law enforcement, and also for correctional. Increased penalties, I keep on voting against them in committee and not voting for them on the floor. I am very concerned about that particular both cost and like to hear what you feel the implications are. So those are my requests, and hope to hear about them as we go forward.
Okay, anyone else? In that case, we will first hear from Ms. Anita Lee from the Legislative Analyst's Office. Ms. Lee will be followed by the Proponents panel, an Opponents panel, an opportunity for public comment. Ms. Lee, thank you for being here, and please start us off.
Great. Thank you so much. Anita Lee with the Legislative Analyst's Office. The sergeants have distributed a handout that we will be using as a guide today for our comments related to this proposed initiative. If you turn to page 1 of the handout, we first provide an overview of the LAO's role in the initiative process. And the LAO is really involved in at two different distinct points in the process. The first is that state law requires our office to work with the Department of Finance to prepare a joint impartial fiscal analysis of each initiative before it can be circulated for signatures. State law requires that this analysis provide an estimate of the measure's fiscal impact on the state and on local governments. The analysis must be submitted to the Attorney General's office within 50 calendar days of the initiative's submission date. A summary of the estimated fiscal impact is included on the petitions that are then circulated for signatures. The next point that the LAO is involved in the process is after an initiative collects sufficient signatures to qualify for the ballot. At that point, state law requires our office to provide impartial analyses of all statewide ballot measures for the statewide voter information guide, and that will include descriptions of the measures as well as its fiscal effects. We are currently in the process of preparing those materials for the November ballot. If you turn to page 2 of your handout, we provide some background on the current regulation of firearm and ammunition sales in the state. First, under federal and state law, certain individuals are prohibited from owning or possessing firearms. Such prohibited persons include individuals who are convicted of felonies or certain misdemeanors, those found by a court to be a danger to themselves or others due to mental illness, and those subject to a restraining order. In California, individuals who are prohibited from owning firearms are also prohibited from owning ammunition. Next, both federal and state law have regulations pertaining to firearm sales. Under federal law, firearms dealers must request background checks from the National Instant Criminal Background Check System, or NICS, of individuals seeking to purchase firearms. NICS searches a number of federal databases to ensure that the purchaser is not a prohibited person. As permitted by federal law, California chooses to process these requests, which then also allows it to search various state databases to ensure that the individual is not a prohibited person. DOJ, California DOJ, also maintains a database that matches the state's prohibited persons list against the state's list of firearm owners. This allows DOJ agents to then seize firearms from individuals who have become prohibited after legally purchasing their firearms. Other state regulations related to firearms include a 10-day waiting period before a firearm may be transferred to a purchaser and various reporting requirements related to firearms purchases. Fees charged to firearm vendors and purchasers generally offset DOJ's costs related to regulating firearm sales. If you turn to page 3 of your handout, in contrast, federal and state laws generally do not regulate ammunition sales in the same manner as firearm sales. However, there are some state regulations that apply to ammunition generally. So for example, since 2000, state law has banned large capacity magazines, which is defined in law as ammunition feeding devices with a capacity to hold more than 10 rounds. However, individuals who possessed large capacity magazines before 2000 are allowed to keep them for their own use. Turning to page 4 of the handout, we shift our attention to the major provisions of the proposed initiative. The first major provision is that the initiative proposes to regulate all ammunition sales in a manner similar to firearm sales, and there are a few components here. The first component is ammunition vendor licenses. The measure generally requires that individuals or businesses obtain a 1-year ammunition vendor license from DOJ to sell more than 500 rounds of ammunition in a 30-day period. Firearms dealers that are licensed by the state and federal government would be automatically deemed a licensed ammunition vendor. DOJ would be authorized to charge a fee to offset its costs related to these provisions. The second component is ammunition purchase authorizations. Individuals who purchase authorization would be required to obtain a 4-year ammunition purchase authorization from DOJ and must be 18 years or older and not a prohibited person. DOJ could charge a fee of up to $50 per person, adjusted annually for inflation, to offset its costs related to administering this section. Before a transaction, ammunition vendors would be required to verify with DOJ that an individual has an ammunition purchase authorization. Vendors would also be required to report certain information, such as the purchaser's identification information and the type of ammunition purchased, to DOJ for retention in a centralized database. The final component of this regulation is kind of a whole bunch of requirements related to ammunition. For example, it requires that nearly all ammunition sales, including internet and out-of-state purchases, be conducted through a licensed ammunition vendor. Turning to page 5 of your handout, the next major provision is that the proposed initiative would implement a new court process to ensure that individuals who are convicted of offenses that prohibit them from owning firearms would surrender them near the time of conviction. For example, it requires that probation officers report to courts on whether offenders have actually surrendered their firearms. If a court finds that an offender did not surrender his or her firearms within 14 days of sentencing, the court is required to order that the firearms be seized. Local government and state agencies would be authorized to charge a fee to reimburse their costs related to the seizure of the firearms. On the second half of this page, there are approximately 3 other major provisions that we would like to bring to your attention. The first is that the measure would generally ban all large capacity magazines. Individuals who possess these magazines would either have to remove them from the state, sell them to a licensed firearms dealer, or surrender them to law enforcement. Second, the measure includes a number of reporting requirements related to firearms and ammunition. For example, the measure requires that ammunition vendors would be required to report the loss or theft of ammunition within 48 hours, similar to current requirements related to firearms. Finally, the measure proposes some changes to the penalty for the theft of firearms. Currently, theft of firearms worth $950 or less is generally a misdemeanor punishable by up to 1 year in county jail. Under this measure, theft of a firearm would be a felony crime punishable by up to 3 years in state prison. Additionally, individuals convicted of a misdemeanor for the theft of a firearm, such as those convicted before the measure would be enacted, would be prohibited from owning firearms for 10 years. Turning to the final page of your handout, page 6, we've identified 3 major state and local fiscal impacts from the proposed initiative. The first is that the measure would result in increased state costs to support new DOJ regulatory requirements. Some of these costs would be one-time in nature, such as for the development of the various databases, and some would be ongoing, such as for staff to process the authorizations. These costs would likely be in the tens of millions of dollars annually, but would likely be offset by various regulatory fees authorized by the measure. Second, the measure would likely result in increased court and law enforcement costs. The state trial courts, as well as state and local law enforcement, would likely experience workload related to the new court process and the removal of firearms. The total magnitude of the costs associated with this workload is unknown, but could be in the tens of millions of dollars annually. Actual costs would depend on how this measure was implemented, such as whether existing resources were reprioritized to accommodate the workload. Additionally, some of these costs would be offset if local governments and state agencies charged and collected fees as authorized by the measure. Finally, the new and increased penalties that are authorized by the measure could result in increased correctional costs to state and local governments. The magnitude of these costs would depend primarily on the number of violations and how the provisions of the measure are enforced. Thus, the potential increase in cost is unknown, but would unlikely exceed the low millions of dollars annually. With that, we've concluded our comments and are happy to answer any questions you might have.
Thank you, Ms. Lee, and it's as the former chair of Budget Sub 5, it's good to see you here. And I know we've had numerous discussions on funding. And the thing that has always been frustrating for me, I have this saying all the time, that the key to what we do is not necessarily legislation. It's more about implementation. And a lot of times we have great legislation, but if it's not implemented right, it falls by the wayside or it doesn't get fully done. With that said, and I'm probably channeling Assemblymember Jim Cooper now, but he's always made a very cogent point. Are we giving DOJ enough money to be able to get the job done? And I think we've tried in our budget subcommittee on several occasions, whether it was droves or drugs or things of that nature, and with other legislation coming in for adult use marijuana, this could be an extremely large load on the department to try to administer if both these initiatives were to pass. And so one of the frustrating things for me has always been when we ask DOJ if they need any money, a lot of times they say no, and then we have a large backlog. And that could be very frustrating, not only for the proponents of any legislation, but the opponents. It can be very frustrating. And so I want to make sure that whatever we propose, one, that DOJ fully understands that they need to ask for all the resources that they can, so this body and the governor can provide that. And if there's a way to ensure we can do that. And then two, whatever monies we give to them, because this has been another criticism, that those monies that go toward this initiative stays in this initiative, and it doesn't get moved over to do something else. And if there's a way to ensure that the monies that we collect for this initiative stays here, and it can only be used to this and can't be siphoned off for something else, because I think that further diminishes our ability to regulate this in an effective manner. So I know that's a lot, but again, can you comment?
Sure. So in preparation, when we prepare our fiscal impact letters and our analysis, we talk to both the proponents and the opponents. But as part of our work, we also reach out to the departments. So related to this initiative, we have had conversations with DOJ, we've had conversation with the courts, et cetera. So specifically related to DOJ, there are certain uncertainties about the amount of revenue that would come in and then the expenditures that go out. So one of the things that I mentioned was the measure requires the ammunition purchase authorizations, and DOJ can charge a fee of up to $50, adjustable for inflation. So there are kind of a few key questions, I think, in terms of the revenue. How many individuals will actually be coming forward to purchase these authorizations? We're not quite certain. We have to make certain assumptions. But then there are also questions in terms of at what point do they come forward? Is it in year 1, year 2, year 3, at what point? The other thing is then accordingly on the expenditure side, DOJ would need to ramp up at some point. There are kind of these initial one-time costs in terms of developing the database, et cetera. There are certain parts of the initiative that don't go into effect immediately. So not, you vote, it gets enacted and then it goes into effect. There's a little bit of a delay. And so I think part of, in our conversations with individuals, part of that is to allow for planning and kind of ramping up for that. I think as the measure would, to the extent it was enacted, I think that the legislature could certainly have conversations with DOJ about whether or not the revenue is sufficient to then match their expenditures. I think at this point, as part of our conversations, we have been having those conversations, and we think that a good chunk of that, if a large portion of that would be offset by the fees that are collected. The second piece in your question in terms of making sure that the funds are dedicated and kind of partitioned off. The initiative does create 2 special accounts. Both are continuously appropriated. One is for the ammunition vendor license fee, and then one is for the ammunition purchase authorization fees. And so the money is kind of separated. So you referenced kind of the budget process. You would think of it like, the same way we have a DROS account, we're going to have kind of 2 new special funds related to this measure.
Okay, and so I just want to ensure that we have an understanding of how it's spent, because I think some of the discussion we've had, for example, with the DRO's account, monies were spent, and in our committee, subcommittee, we had long discussion that may not have been the appropriate way to spend it. So it sounds like the initiative doesn't have any guidelines for that, and that may be something we need to express early on, how the money should be spent, so there won't be any misunderstandings or other interpretations later on.
There is, in creating the special fund, there are certain guidelines. For example, it makes reference to implementation or enforcement of this program or these provisions. But in terms of your larger question about kind of legislative involvement, even though the funds are continuously appropriated, the legislature could certainly ask DOJ to come forward and discuss its expenditures, discuss its plans for implementation. The legislature can certainly do that.
Thank you.
Yeah, Ms. Lee, just to follow up on those, do we have an estimated number of people who buy ammunition in California? Presumably, that would be all gun owners.
Yes. So there is no database that kind of collects this information on the number of ammunition purchasers. In our fiscal impact, and we are, looking at our model again, because as I mentioned, we're currently in the process of preparing our ballot measures, but we do make certain assumptions about the number of ammunition purchases that would potentially happen based on the number of firearms owners.
And are we assuming that the background check would be roughly similar to what someone goes through now to become authorized to own a gun?
I think so. I think that there are a few technical issues that I think DOJ would potentially need to work through, but that is going to be more of an implementation issue.
So that could be done fairly quickly and efficiently.
I think so.
Yeah. I think for the purchasers, right?
Yes. I mean, I think that there are, like, as I mentioned, implementation issues that DOJ would need to work through, including how the new databases are kind of constructed, how the information is stored, and how the information communicates with one another. I think that's one of the discussions that both budget subcommittees have discussed related to firearms.
So, and these would presumably be ongoing positions, since after the initial sign-up, the authorizations would have to be renewed every year in the case of a vendor, or every 4 years?
Yes.
In terms of an individual purchaser. And did you do any calculations as to whether the $50 fee would cover that cost?
I think it really depends on the number of, the large variable is the number of individuals that come forward to seek the ammunition purchase authorization. Based off of our assumptions, we think the bulk of the costs would likely be covered, but on the expenditure side, it also relies on, DOJ not coming across any unexpected issues in terms of developing the database and things like that.
Because the vendor license, we must have business licenses, hopefully, for all these people now, right?
So on the vendor licenses, our firearms dealers have licenses and kind of are regulated that way. Licensed firearms dealers would automatically be deemed ammunition vendors, and so they would not be kind of captured here. Here, in terms of the licenses, it would be individuals who purely sell ammunition, and there is kind of a question about how many businesses or individuals that would encompass as well.
Yeah, might not be too many. But what about mail order sales? And what I'm thinking about is one of the cities in my district discovered a number of years ago that there were people selling firearms who had never taken out a city business license. But they were federally licensed in some way and dealing with quite large numbers of guns and ammunition.
So the measure does require that any internet purchase or, more remote type, which I think would encompass the mail order, would have to be processed through a licensed ammunition vendor. So that is included in the measure.
We would find that out. Now, I know there is some pending legislation that is somewhat similar to this provision in the initiative. Are you familiar with it? Is there any quick comparison you could give us?
So there are a number of pieces of legislation that touch on different parts of this initiative. Senator Hancock, you actually have one of them related to the large capacity.
That's the high-capacity magazine.
Yes,
Right.
exactly.
Okay.
But there are other ones, including Senator De Leon has one as well. I would break it into kind of three classifications. I think the first piece is that there are some things that are exactly identical. So for example, the definition of ammunition. I think then the second area is related to touching on the same issue, but choosing a different approach. And so to give you an example on that, Senator De Leon's bill takes a different choice and a different tact on how to do the ammunition purchase authorizations and how ammunition sales will happen. And so that's clearly, a decision that the legislature will be having discussions about. And then I think the third area is that there are some components of the initiative that are not included or not touched on by any pieces of legislation. Most notably, I think the new court process. I'm not aware of any legislation that kind of touches on that piece. But vice versa is also true. There are certain pieces of legislation that touch on areas that the initiative doesn't touch on as well.
Okay. Thank you.
I don't know who hands were first, but I'll start with the budget chair because I need to grovel to him later. So, Mr. Leno.
Good decision, Mr. Chair. Thank you. I will be as succinct as possible. I do have a number of questions, somewhat following up on a number of points that both of you have raised already. You had mentioned, Ms. Lee, that the new special funds would be continuously appropriated. I would imagine they'd be appropriated to DOJ in most cases for their costs.
I think that is the idea. The way the legislation reads is that the funds are continuously appropriated, but I think that that's the general understanding.
Now, since we don't know how many people will proactively step forward to either get the vendor license or the individual purchasing license, we don't know how much money will be in those funds. So the measure doesn't, it just says funds will be continuously appropriated. It doesn't say to whom or in what amount.
So in terms of the first question, or the first part of your question, in terms of kind of the initial startup costs, the measure does authorize a $25 million loan from the general fund initially for startup costs. And so that would cover kind of the initial portion, development of the databases and things like that. And then on the special funds, once the fee revenue is kind of coming in and it's being collected, there is language then that one continuously appropriates the dollars for kind of support of the program, which I think is what we would interpret to mean DOJ, as well as to repay that loan.
Okay. And as the chair had pointed out, the dealer record of sale account use is specified very clearly in statute. In fact, we had to amend it slightly so it could be used for the purpose of confiscating those who are prohibited from possessing weapons. So the measure does not have those kinds of details in it. Is there, that's question one. And number two, if there are no details in the measure as to exactly how these new funds can be used, is there anything that would prohibit the legislature from coming back with legislation specifying how those funds can be used?
So the language inside the initiative is a little bit different from the language that is related to DROS, which you are familiar with.
Yes.
The language here is more in line with, and I'm kind of quoting from the initiative, are continuously appropriated for the purposes of implementing, operating, and enforcing. And it depends on how you interpret each of those different clauses. And in terms of the legislature kind of providing further clarification, the measure allows for legislative action if it's furthering the purposes of the initiative by a vote of 55% of both houses. To the extent, though, that the legislature was interested in making changes that conflicted with the initiative, then it would require a vote of the people.
Of course, okay. And then with regard to your point made on the bottom of page 4 that nearly all ammunition sales, including internet and out-of-state purchases, be conducted through a licensed ammunition vendor. Is there any way to really enforce that? Because that internet seller could be anywhere on the planet, right?
Yes. So this is a question that we discussed with the DOJ, and I'm sure we'll be having further conversations on that. I think that they would kind of compare it to similar restrictions that are currently in place related to firearms, and so that there's an onus on both who is selling it, remotely if they're kind of out of state, as well as on the purchaser. And so one of the examples that I was given is, if you're purchasing a firearm out of state and there's notifications on the website that says, to the extent that you purchase it, there may be other state laws that prevent us from doing X, Y, and Z. So I think that that is one of the implementation issues that would need to be addressed, to the extent that the measure went into effect.
How well do we ensure that illegal internet firearm sales are not occurring?
I don't think that that's something that I can answer. I think that's a question that's better directed to DOJ.
Sure, but this would be modeled on that. So.
I think the concept is along that lines, yeah.
Okay. And then moving on to page 5 of your analysis with regard to the surrendering of firearms at conviction.
Yes.
It says that if a court finds that an offender did not surrender his or her firearms within 14 days of sentencing, it is required to order that the firearms be seized. Is there any penalty for the recently convicted for not having surrendered? And is that a new crime? If I'm convicted, I'm now prohibited and I don't surrender.
So the court is going to be issuing it, issuing that warrant to the extent that there is probable cause. There's no penalty for the individual surrendering it, actually like taking it and transporting and submitting it.
My question is there a penalty if I don't? Because the measure says I'm
Yes.
required to do so once I fall into the category of prohibited person.
I think it then falls, I think that might be a question that is better directed to the proponents, because I don't recall specifically related to that. I think my understanding is that it kind of falls into the queue of they're not supposed to have firearms and or ammunition, and so then it would be subject to removal the same way it currently,
Right.
current authorization.
So as we've been working with DOJ on the ever-growing mountain of prohibited weapons.
Yes.
And the growing number of names on our prohibited persons list.
Mm-hmm.
This, it sounds as you've described it, like an opportunity for us to keep that mountain from growing any higher and the list from growing any longer. It doesn't really address in any way the current
backlog.
The current backlog.
Correct. I think the intent of the measure is to obtain the firearms right up front,
Right.
At the court process when you've been adjudicated. And so I think the intent is to kind of remove it at that point right away. But you're correct in terms of the existing backlog that exists. It wouldn't necessarily address that to the extent that the individual who's convicted does not have firearms that are already in the queue. So for example, they have firearms, they're already not supposed to have them, they get adjudicated for something else, and then when they get adjudicated for that new crime, they're supposed to provide a list of all of the firearms that they own and possess.
Right. Would this also impact those who have imposed upon them a restraining order?
So an individual who has a restraining order is generally a prohibited person.
But at the time that I have a restraining order imposed upon me, just as at the time I'm convicted of a crime that makes me prohibited, is there any similar process of seizing my weapons when I have that restraining order placed upon me?
I think it would fall in line with the precipitating, the event in question is the conviction. So it's the conviction for the felony, the certain misdemeanor, or if there is some sort of, I'm assuming, a restraining order.
But there's no conviction involved with a restraining order.
Oh, I'm sorry, that is correct. So this is predicated specifically on a conviction. So it's on the adjudication of a court process. So to the extent that there's a restraining order, I do not know if this would apply.
You're not sure if the measure's clear, or you're just not sure?
I think the measure focuses on the conviction. I don't know, depending on implementation, because the intent is, the broader intent is to remove firearms from individuals earlier on in the process.
Right.
So I don't know to what extent, in taking that broader interpretation, it would then be applied to restraining orders. The measure itself, in terms of the court process, is specifically related to conviction.
Got it. And is there anything that prohibits a court today from seizing weapons of those who are convicted of crimes that make them prohibited persons?
So that is something that is a question that we're having conversations with the various stakeholders about. Currently, the court provides and informs the individual when they're being adjudicated that they're not.
Sometimes not.
Yes, I think depending on what court you're in and depending, kind of who's adjudicating the process could be different. But conceptually, the intent is currently under state law. The courts inform the individual. The question about whether there's authority to kind of seize the weapons at that point, I think we're not clear on, but we're having discussions about that.
Thank you. And Madam and Mr. Chairs, I'll just have one last question. And this one I apologize up front because I have minimal information to even offer you. But I had heard or read something to the effect that with regard to the surrendering of firearms or the interaction of this measure with our APPS program, that we're aligning it in some way with some federal, statute or regulations, and the concern is that we might be surrendering some of our autonomy of our APPS program. Is there anything relative to aligning with the federal government with regard to APPS?
I haven't heard that, and I'm not quite clear. I mean, we're happy to follow up to the extent that.
So you did make mention briefly that there is an APPS, there is a federal database.
Yes.
And we have our own database.
Yes.
Are we deferring to the federal database in any way, and how do those two interact?
No, so there's the broader federal database, and then individual states can have their own state.
We're one of the few that does.
We're one of the few, we're one of 13 essentially that chooses to process both the federal and the state, because by doing the federal as well, we can do the state. There are other states that do kind of a bifurcated system where in certain sales they go straight to the federal government, process those transactions that way, and then they process other sales with the state. We're not one of those states. So California is it goes straight through the state, the entire process.
Okay. Thank you very much.
Thank you. Senator Glazer?
Thank you, Mr. Chair. I had a couple questions on this issue of the large capacity magazines. First, Ms. Lee, do you know how many of those are in circulation today in California?
I do not. That's a question that's probably better directed to DOJ. We're happy to follow up on that and follow up with your staff on that.
Okay, thank you. And what would be the penalty if one didn't comply with the requirements of this measure to an individual who had a large capacity magazine as defined?
I am just going to need a moment for that. So the penalty would be for each magazine, it would be an infraction punishable by a fine not to exceed $100 per large capacity magazine, or a misdemeanor punishable by a fine not to exceed $100 per large capacity magazine, by imprisonment in county jail not to exceed 1 year, or by both that fine and the imprisonment.
So if someone did not do the three requirements in this measure, and they encountered law enforcement in some capacity, what you just said was there could be a $100 maximum penalty plus some jail time if they didn't turn it in. Is that right?
So it would either be an infraction or a misdemeanor. So on the infraction side, that would be just the fine. On the misdemeanor side, it could be fine as well as up to 1 year in county jail.
And do you know if there's any other states that have this requirement in law?
I do not.
And are you aware of any other provisions that we have in law relative to weapons that would require a confiscation that this requires? So, for example, when we did the ban on assault weapons, we required that those who had them in their possession, they had to register them, right? We didn't go and take them from them.
Yes.
And this would actually, and so is there anything that we have enacted in California that would actually require a confiscation of, we grandfather things in, but would we actually require them to turn them in?
I think that that would be a question better directed for DOJ because they have a much broader breadth of kind of the various firearm regulations. I think our focus specifically in looking at this initiative is really on kind of the firearms and ammunition sales.
Great, thank you.
Assemblymember Patty Lopez.
Can you detail how the estimated potential increase correction costs or the potential initiative estimates say unlikely say that low millions of dollars annually?
I'm sorry, can you repeat the question?
Can you detail how estimate the potential increase correction costs of the proposed initiative estimate say unlikely to say that low millions of dollars annually?
So this refers to page 6 of our handout, that last piece. And so in looking at that, part of our analysis is driven by the change to the penalty for the theft of a firearms. So for those of you who followed Prop 47, that was something that was changed by Prop 47, and so when we say under current law it's a misdemeanor, this measure would change it back to felony. And so we did look at, we used data to kind of look at the number of individuals who would potentially fall within that classification. And so by using those numbers, we did estimate that it would be in, potentially in the low millions of dollars. But again, it depends on the number of violations and how the measure would be enforced.
Okay, thank you. I'm sorry. I started to my left. I have a tendency to go to my left, but Mr. Quirk was next, and then Ms. Melendez.
With regard to confiscation of magazines, wouldn't we be required to pay for the magazines? Otherwise, isn't it a taking?
So that is a question that you may like to direct to the proponents when they present before you next.
Thank you.
I think part of the issue here in terms of the measure is that there are 3 choices in terms of, there's a delay when the measure goes into effect. So it's by July 1st of 2017. And so you have 3 options. You can remove it from out of state. You can sell it to a licensed firearms dealer. And then the third is you can surrender it. And from our conversations, I think that that choice was partially to address the takings issue.
Thank you.
That would be a question better directed to the proponents.
Ms. Melendez?
Thank you. Ms. Lee, I just have a very brief question. You have responded to several inquiries about the cost of this initiative. Would you characterize your financial estimate of this initiative as conservative?
I would say that we, to the extent possible from the conversations that we had with both the departments and the stakeholders, we made the assumptions that we thought would be reasonable. We do acknowledge that there is uncertainty in a number of different places. For example, the individuals that would step forward and actually go through the ammunition purchase license authorization. That is something that we continue to look at, but there's not data necessarily in that area specific to that issue. And so some of it will just rely on how it's implemented to the extent the measure goes into effect, obviously.
Okay, and I ask because this is an elaborate system we're talking about. We're talking about separate accounts. We're talking about development of software. We're talking about making sure systems that there's connectivity between them. It's not a simple task. And so I can't help but think that the cost is going to end up being much more than what we estimate it to be, not on purpose, but just that's how things, usually go. So I just wanted to get your kind of view of if you took a conservative estimate or if you, decided to go higher than what you thought they would need or a little lower. Just, your thoughts on how you came up with that number. But I appreciate your response. Thank you.
Are there any other questions from committee members? Thank you, Ms. Lee.
So we can move to our first panel, which is proponents. And we have with us Ari Freelick from the Law Center to Prevent Gun Violence, Julie Leftwich from the Law Center to Prevent Gun Violence, and Tom Willis, attorney. Welcome to the committee. Now, I believe what we discussed was equal time for each side, so that there will be 45 minutes for proponents and 45 minutes for opponents.
Okay, good morning. My name is Juliette Leftwich, and I'm the legal director of the Law Center to Prevent Gun Violence. We are honored to be partnering with the Lieutenant Governor on the Safety for All initiative, and we're grateful to have the opportunity to speak before you today. The Lieutenant Governor is attending a CHP officer's memorial this morning, and he is unable to be with us. I'm going to begin by providing the historical and factual context of the initiative, and then my colleague Ari Freilick will provide in-depth information about each of the initiative provisions. After that, Tom Willis, who is an election lawyer with expertise in statewide initiatives, will discuss the fiscal impact of the Safety for All initiative. I will then close with a few final remarks. The Law Center was formed in the wake of the 101 California Street assault weapon massacre in downtown San Francisco in 1993. That massacre left 8 dead and 6 wounded. The shooting took place at the law firm of Pettit and Martin. I personally got involved because my former law firm was located in that building. I was on the 23rd floor, well below the 35th floor where the shooting took place. But the tragedy affected me profoundly. Within a few days, lawyers from Pettit and Martin had formed a unique organization to use the skills of lawyers to do something about our nation's epidemic of gun violence. I knew I had to get involved. I volunteered for a few years, and then I was able to come on staff, and I've been with the organization ever since. The Law Center is new to initiative work, but we are not new to gun violence prevention policy. We've been doing that work for the last 20 years. We provide free assistance to state and local legislators around the country who are seeking to enact or to defend laws to reduce gun violence. We monitor all state gun laws. We rank state gun laws. We monitor Second Amendment litigation around the country, and we file amicus briefs in those cases. We also provide model laws in a variety of areas. The goal of our work and the goal of the Safety for All initiative is simple: to reduce gun-related deaths and injuries. No one in this room today can deny that gun violence in America has reached epidemic proportions, or that something must be done to stop the senseless bloodshed. Mass shootings like those that took place at the 101 California Street building, or in Newtown, or in San Bernardino, receive the most media attention, but they're really the tip of the iceberg. Every day, 80 Americans are killed with guns. Today, 80 Americans will die from gun violence. In fact, since the 101 California Street massacre, 700,000 Americans have died from gun violence in this country. In California, nearly 10,000 people die each year. 10,000 people are shot each year, and approximately 3,000 of those die. The reason for these staggering statistics is clear. Our nation has incredibly weak gun laws. The U.S. has the weakest gun laws of all of the industrialized nations in the world, and we have the highest rates of death related to guns. The American Journal of Medicine found recently in a study that the U.S. gun homicide rate is 25 times higher than that of other industrialized nations in the world. It isn't that Americans are inherently more violent than people in other countries or that we suffer from more mental illness. It's just that other countries have sane gun laws to keep guns away from dangerous people, and we do not. One of the first priorities of the Law Center was to work for the passage of the federal assault weapons ban. That was important to us as an organization because the assault weapons used in the 101 California Street shooting were purchased legally in Nevada, where assault weapons were not prohibited and still are not prohibited, even though at the time they were prohibited here in California. In 1994, Congress did enact a federal assault weapons ban, which included also a ban on the manufacture and sale and possession of large capacity ammunition magazines. And the possession piece is what is included in the initiative. Unfortunately, however, the law had a 10-year sunset provision, and it was allowed to expire in 2004. Because Congress is beholden to the gun industry, it has repeatedly failed to enact even the most modest gun reforms over the past few decades, despite overwhelming public support for those measures. That's why it's so important for states to step up. Fortunately, we've had many courageous leaders here in California, including several members who are on this committee. And the legislature has led the nation in adopting strong gun safety laws here in California over the last 20 years. Despite this progress, however, much work remains to be done. California's laws still have loopholes that allow dangerous people to obtain guns and ammunition and then commit acts of gun violence. For example, our laws allow criminals to buy ammunition without any background check. They allow for the possession of large capacity magazines, even though the sale and manufacture of those dangerous military-style items has been banned since 2000. Our state laws also provide no clear process for convicted felons to relinquish their weapons once they become prohibited. As a result, as Senator Leno mentioned, we have a mountain of people who are in the APPS database. That's the database of armed and prohibited people. There are now a backlog of 17,000 people in that database who own more than 34,000 guns, including thousands of assault weapons. When we were approached by the Lieutenant Governor to help craft this initiative, our recommendations were designed to close the loopholes that currently exist in our state laws. Our recommendations were also based on legislation that had been shaped and vetted by the legislature, often after similar laws had been passed at the local level with our assistance over the last 20 years. Our recommendations were also consistent with the longstanding priorities of our gun violence coalition partners around the state. I'm now going to turn things over to Staff Attorney Ari Freilich, who will provide much more detail about each of the initiative provisions. As you'll hear, the provisions are overwhelmingly supported by the vast majority of Californians, and none of the provisions are radical. They're simply intended to keep guns and ammunition out of dangerous hands.
Thank you.
Good morning. My name is Ari Freilich. I want to thank you for your committee's work to keep the public safer and freer from violence. And thank you for the opportunity to speak with you today to discuss in detail how this ballot initiative would further that shared goal. As Juliet mentioned, this issue is personal to us, to the people we work with and for. Well over 1 million men, women, and children were shot in this country in the last decade, and we know painfully, unceasingly well, that behind that number, the epidemic's impact is felt one name and voice, one bullet, one brutal personal tragedy at a time. And we're here because we believe reasonably that more can and should be done to protect California's families and keep lethal weapons, lethal products out of dangerous hands. The Safety for All Act would build on California's proven track record in this area and expand what has been shown to work in local governments here in California and elsewhere by proposing a package of 7 major policy reforms. And I apologize to the extent that my remarks are duplicative of Ms. Lee's presentation, but I'd like to walk you through each of these proposals and be absolutely clear and specific about what we're advocating and why these policies matter for California's families. The Safety for All Act's first major policy reform addresses a dangerous and costly enforcement gap in removing firearms from prohibited criminals at the point of conviction. As you know, California and federal law prohibit certain categories of dangerous individuals from possessing firearms. And when individuals fall into these prohibited categories, existing California law requires them to relinquish possession of any firearms they previously owned or controlled. However, state law provides essentially no mechanism to ensure that individuals who have been convicted of a prohibited criminal offense, no matter how serious, actually relinquish possession of their firearms upon conviction. Existing California law, to address your point, Senator Leno, does currently establish a clear and enforceable process for individuals subject to certain protective orders, such as domestic violence restraining orders, GVROs, to lawfully relinquish their firearms for the duration of that prohibiting court order. And importantly, that law has teeth. It requires such individuals to provide written receipts to a court of law, verifying that they actually relinquished the firearms within specified timeframes. This existing law also authorizes courts to issue warrants to recover illegally owned firearms from abusers who failed to comply. Studies have shown that this process has been highly effective at removing illegal firearms from individuals covered by the law. Since 2000, when California first mandated that all domestic violence protective order respondents relinquish their firearms pursuant to this policy and verify compliance with the courts, the number of firearm-related domestic violence calls to law enforcement has fallen by 44%, even as the overall number of domestic violence calls to law enforcement has risen substantially. California has thus far failed to extend this effective best practice to firearm relinquishment in other contexts. As a result, according to DOJ, and as you well know, thousands of prohibited individuals illegally retain possession of firearms each year and are added to our apps database. More than 7,700 individuals were added to that database in 2014, of which at least 42%, more than 3,200 people, were individuals who illegally retained firearms after a new criminal conviction. The consequences of this noncompliance are both dangerous and costly. The State Department of Corrections and Rehabilitation reported that in 2013, over 8% of California's newly admitted felony inmates and nearly 10% of parole violators sentenced to a new prison term were incarcerated because of illegal weapon possession charges. At the end of 2013, California taxpayers were paying to incarcerate more than 4,700 people whose controlling, most serious offense was illegal weapon possession. This number does not encompass the thousands more incarcerated for crimes related to the use of those illegal firearms. DOJ has also reported that over a 3-year period, nearly 6,000 Californians were arrested solely because they illegally possessed firearms after a prohibiting criminal conviction. Nearly 7,000 more were arrested over that period for offenses that included that charge. Instead of implementing a proactive relinquishment process on the front end, California currently requires teams of law enforcement officers to go door to door to recover these prohibited offenders' weapons. While these enforcement efforts have been essential and constructive, this process imposes significant manpower and financial burdens on law enforcement and, in too many cases, proves too little, too late to prevent prohibited offenders from using firearms to perpetrate violence in our state. It would be cheaper, safer, and more effective to also remove offenders' illegal firearms at the point of conviction. And the Safety for All Act would do just that by implementing a clear and enforceable process for the relinquishment of firearms by prohibited offenders. More specifically, beginning January 1, 2018, this measure would require courts to order prohibited offenders to relinquish their firearms and to provide the offenders at the time of conviction with a standard relinquishment form. The form would, among other things, inform the defendant that they are required to relinquish all firearms within specified timeframes by selling or transferring the firearms to a licensed firearms dealer or by transferring them to law enforcement. It would require defendants to declare any firearms that they possessed at the time of conviction and to name a consenting designee or law enforcement agency to relinquish those firearms on the defendant's behalf. Most importantly, this measure would require the defendant or designee to file the completed relinquishment form with a court-assigned probation officer, along with receipts from the law enforcement agency or licensed firearms dealer who took possession of those firearms to verify that the offender in fact relinquished all firearms prior to sentencing as required. The measure would require the assigned probation officer to include in his or her standard pre-sentencing report to the judge information regarding whether the offender properly relinquished all firearms indicated on the relinquishment form or by the AFS database. Courts would be required to verify that relinquishment occurred before final disposition of the case, and when the court finds probable cause that the defendant failed to comply, the court would be required to order the search for and removal of the defendant's firearms at any location where the judge has probable cause to believe the defendant's firearms are located. This is similar to the domestic violence restraining order context. This relinquishment process implements best practices from that domestic violence restraining order context by providing clear and mandatory procedures to all prohibited offenders, by expressly requiring proof of relinquishment, and by requiring further enforcement action if the offender fails to comply with the law. It would be an important overdue step to proactively remove illegal guns from our communities and would help significantly reduce growth in the apps backlog. The Safety for All Act's second major policy reform addresses a massive enforcement gap regarding dangerous persons' access to lethal ammunition. Existing California and federal law both prohibit convicted felons, domestic abusers, and the dangerously mentally ill from purchasing or possessing both firearms and the ammunition that makes firearms deadly. But state and federal law do essentially nothing to enforce that law, to prohibit dangerous people from purchasing ammunition. As a result, convicted felons and other prohibited persons in our state are able to have unlimited quantities of ammunition delivered to their door as if ordering a pizza, without showing identification, passing a background check, with no questions asked. Law enforcement authorities also have no idea who is selling ammunition in our state because individuals selling this lethal product do not have to be licensed, pass a background check, or document their sales or business practices in any manner. As the California Police Chiefs Association noted before the Senate Public Safety Committee in 2013, it is easier to purchase ammunition in California than a packet of cigarettes or allergy medicine. This lack of regulation has dangerous consequences. Researchers examining ammunition sales from 10 retail outlets in Los Angeles over a 2-month period found that felons and other illegal purchasers had obtained 10,000 rounds of ammunition in that 2-month period from those 10 stores alone. In the wrong hands, every one of those bullets posed a significant threat to human life in our state. The California legislature previously recognized the importance of closing this gap in our state's gun laws. In 2009, Governor Schwarzenegger signed then Assemblymember De Leon's AB 962, which would have imposed important record-keeping requirements on handgun ammunition sellers, and would have required handgun ammunition sales to be conducted in person instead of by mail. Unfortunately, that law is being challenged in ongoing litigation related to the allegedly vague definition of handgun ammunition and is subject to an injunction preventing its enforcement. The Safety for All Act would remedy that situation and help keep all types of ammunition from falling into dangerous hands by requiring ammunition sellers to be licensed, to conduct background checks on their purchasers and their employees, and to submit records of ammunition sales and lost or stolen ammunition to law enforcement. To drill down more specifically, starting January 1, 2018, individuals who sell more than 500 rounds of ammunition in a month would be required to obtain a license from the Department of Justice. DOJ would start accepting applications for ammunition vendor license 6 months in advance. The licensed firearm dealers would not need to apply. They would be automatically deemed ammunition vendors. DOJ would be authorized to issue these licenses to individuals who provide specified documentation, including appropriate local business or regulatory licenses, if applicable, and a certificate of eligibility verifying that they passed a background check. As with firearm dealers' licenses, an ammunition vendor license would be valid for 1 year and subject to forfeiture for legal violations. The next set of policies aim to align firearm and ammunition seller requirements. Ammunition vendors would be required to obtain a certificate of eligibility from employees who handle or sell ammunition, verifying that they passed a background check. Beginning January 1, 2018, ammunition sales by unlicensed sellers would generally have to be conducted by or processed through a licensed ammunition vendor, just as firearm sales by unlicensed individuals must currently be processed through a firearms dealer. To be clear, this requirement applies to sales, not to the transfer of an ammunition to a hunting buddy in the field or at a shooting range. Ammunition obtained remotely over the internet or from out of state could be initially shipped to a licensed ammunition vendor for physical delivery to the purchaser, similar to existing requirements for firearms. Other states, including New York and Massachusetts, and some cities in California, including Los Angeles, Sacramento, and Oakland, have already enacted these restrictions regarding mail order ammunition shipments. Additionally, beginning January 1, 2019, a licensed ammunition vendor would be required to maintain and report to DOJ records of ammunition sales in a manner similar to DROS records for firearm purchases. This act would also extend existing law governing the straw purchase of firearms to also apply to ammunition, making it a misdemeanor to traffic ammunition to a person with knowledge that he or she is funneling that ammunition to prohibited persons. Finally, and importantly, beginning July 1st, 2019, licensed ammunition vendors would also be required to verify at the point of sale that ammunition purchasers have passed a background check. Instead of making purchasers wait at the sales counter, the law would require them to apply in advance for an ammunition purchaser authorization, essentially an electronic certificate of eligibility, good for 4 years. DOJ would start accepting applications for these authorizations 6 months prior and would be required to process those applications within 30 days, so individuals should not experience delays in obtaining this approval. If the seller is a firearms dealer, he or she may also sell ammunition in the same transaction as a firearm with only the firearm background check required. Once DOJ receives a background check application, it would conduct a full background check, approve all eligible applicants, and maintain an electronic database of authorized purchasers' driver's license or other identification numbers. DOJ would charge a fee not to exceed $50 to conduct a background check on first-time applicants, and this approval would be good for 4 years unless the person fell into a prohibited category in the interim as a result of a new criminal conviction or other event, in which case DOJ would promptly remove his or her identification number from the electronic database. At the point of sale, ammunition purchasers would simply present their ID to the vendor, who would enter the ID number into DOJ's database of approved purchasers. That database would then instantaneously inform the vendor whether the person has or has not passed a background check to purchase ammunition. 4 other states have already enacted ammunition permit requirements. And we believe that this approach, a more nimble electronic version, blends the convenience of the permit-to-purchase schemes with a more timely accuracy and effectiveness of a point-of-sale background check. New York also enacted a law requiring point-of-sale ammunition background checks, but it has delayed implementation of that law because, unlike California, New York does not maintain its own background check system database of prohibited persons and needs time and resources to build what California already has from scratch. I'd also like to note that this act includes certain exemptions to these rules, such as for individuals to lawfully buy ammunition for use at a shooting range without a record of sale or background check required. If the shooting range is also a licensed ammunition vendor, they could also sell ammunition for use both on and off the range, so long as they conduct a background check and document the sale. And just to speak about the effectiveness of these proposals, the California Police Chiefs Association called for enactment of these policies in 2013, noting in a statement to the Senate Public Safety Committee that, quote, each year, millions of rounds of ammunition are sold to felons and other prohibited persons at gun shops and sporting goods across our state. By requiring ammunition vendors to obtain a license to sell ammunition and ammunition purchasers to submit to background checks, this legislation would effectively limit criminal access to the fuel that drives gun violence. We agree. These policies would build on the success that local governments in California have had using more limited record-keeping ordinances to identify and prosecute armed prohibited persons. In Sacramento, for instance, a local ammunition record sales requirement, record-keeping requirement, helped law enforcement discover that in an 18-month period, 229 felons and prohibited persons illegally purchased ammunition in that city. The DA used these sale records to file charges against 197 illegal gun owners. Others were indicted in federal court. The vast majority of these cases were resolved in convictions. Law enforcement officers recovered 160 firearms from these individuals, including explosive devices and thousands of rounds of ammunition during this period. Ammunition background checks have also proven effective at preventing firearm violence. The ammunition permitting laws on the books in 4 other states are weaker than what is proposed here because a person who becomes prohibited after receiving a physical permit would still be able to present that permit to obtain ammunition until it expires. Even so, there's evidence that those licensing requirements have significantly improved public safety. CDC data show that New Jersey and Connecticut both experienced significant reductions in firearm homicides after recently adopting their permitting laws in 2008 and 2013, respectively. The number of firearm homicides in Connecticut declined by 36% between 2012, the year before Connecticut enacted its law, to 2014, the first full year in which the law was in effect, and that is excluding the 26 individuals massacred in that state in 2012 at the Sandy Hook Elementary School. And 2012 is not a cherry-picked data point. The number of firearm homicides in Connecticut was 42% lower in 2014 than in 2011, 43% lower than in 2010, and 30% lower than in 2009. The state's non-firearm homicide rate did not experience this dramatic decline, and in fact, moderately increased over this period. New Jersey State Commission of Investigation released a report in 2007 showing that nearly 3/4 of its retail firearm outlets had sold ammunition to individuals with criminal records. One store alone had sold more than 15,000 rounds of handgun ammunition to 42 felons over a 4-year period. As a result, the commission formally recommended that the state adopt laws to require ammunition sellers to retain ammunition sale records and to require purchasers to present a valid permit obtained pursuant to a background check in order to acquire ammunition. Those laws became effective in New Jersey in mid-2008 and have similarly resulted in significant reductions in firearm homicides in New Jersey. This data is consistent with what we know about background checks. They effectively reduce the incidence of gun violence by keeping weaponry out of the hands of those who should not have them, with relatively minimal inconvenience to law-abiding, responsible citizens. California voters agree. A January 2016 California field poll confirmed that 80% of voters in our state support requiring people to pass a background check in order to buy this lethal product. The Safety for All Act's third major policy reform would require gun dealers to conduct employee background checks and to report lost or stolen ammunition as well as firearms. Currently, California law authorizes but does not require firearm dealers to conduct background checks on their employees to ensure that they are not dangerous or prohibited persons. Because gun dealers' employees have access to such a high volume of firearms, corrupt or criminal employees are a major source of crime guns, responsible for nearly half of the total number of trafficked firearms uncovered in ATF investigations. In ATF trafficking investigations in which a gun dealer or employee was implicated, ATF discovered that 350 black market guns were involved per investigation on average. In the wrong hands, again, every one of those guns posed a significant threat to human life. If individuals must pass a background check to obtain those firearms, we believe it is common sense that the employees selling those weapons should also pass a background check too. The Safety for All Act's fourth major policy reform would help reduce the lethality of mass shooting events in our state by making it illegal to possess the kind of military-style, large-capacity magazines that enable these killings. I'd like to thank and acknowledge Chairwoman Hancock for your strong, consistent leadership on this issue. And as you've long pointed out, these magazines, some capable of holding 100 rounds of ammunition, are designed for offensive purposes to allow a shooter to continue firing large numbers of bullets and multiple targets without reloading. They're the common thread uniting most of the high-profile mass shootings in our country, including the massacre that prompted the founding of our organization, as well as the Cleveland Elementary School shooting in Stockton, where gunmen fired 106 rounds in 3 minutes, killing 5 children and wounding 30 others. The 2011 Tucson shooting, in which a gunman shot more than 30 rounds and killed or injured 19 victims in the span of 15 seconds. The 2012 Aurora movie theater shooting, where a gunman shot 70 people in less than 10 minutes. And the 2012 Sandy Hook shooting, in which a gunman fired 154 rounds and killed 26 children and teachers in less than 5 minutes. In so many of these incidents, the shooter was ultimately subdued only when he finally paused to reload. And studies have found that in mass shootings where large capacity magazines were used, more than twice as many victims were shot, 57% more victims were killed compared to mass shootings where the gunman used conventional magazines. Behind those data points were real and, in too many cases, preventable deaths. A classroom of children escaped to safety at Sandy Hook when the shooter finally stopped to reload. Conversely, in Tucson, a 9-year-old girl was struck and killed by the shooter's 13th bullet. She may be alive today if he had to pause to reload after his 10th round. The California legislature recognized long ago that these military-grade magazines have no place in our communities. Since January 2000, California has generally prohibited individuals from manufacturing, importing, selling, giving, or transferring these LCMs. The legislature did originally intend to grandfather possession of these magazines that were lawfully obtained before 2000. But because they do not have any identifying marks to indicate when they were manufactured or sold, police officers who come upon a stash of LCMs are, practically speaking, often unable to determine whether or not they were lawfully obtained prior to 2000. Instead of serving as a limited grandfathering clause, this gap has therefore made California's existing restrictions nearly impossible to enforce. The availability of magazine conversion kits, which allowed individuals to self-assemble and possess new LCMs before the kits were finally restricted in 2014, also significantly undermined existing law's effort to keep these magazines off the streets. The Safety for All Act would close this dangerous gap in our laws and protect our state from mass shootings, providing a clear mandatory process for individuals to legally dispose of their LCMs by removing them from the state, selling them to a licensed firearm dealer, or transferring them to law enforcement. And as Juliet will discuss in a few moments, this is not a takings, as the courts have made clear. The Law Center has supported adoption of similar legislation to close grandfathering loopholes in states like New York, New Jersey, and Hawaii, as well as at the local level in California, Los Angeles, Oakland, San Francisco, and Sunnyvale, among others. These types of laws have been repeatedly upheld in the federal courts. In Fyock v. Sunnyvale, for example, the Ninth Circuit upheld Sunnyvale's LCM ban and noted that the city presented credible evidence demonstrating that the use of LCMs results in more gunshots fired, results in more gunshot wounds per victim, and increases the lethality of gunshot injuries. The court ruled that the city maintained a strong interest in protecting the public against their potential use. A January 2016 California field poll confirmed that a strong majority of California voters support efforts to rid our communities of these magazines. The Safety for All Act's fifth major policy reform would help law enforcement break up gun trafficking rings and return lost or stolen firearms to their rifle owners by requiring individuals to notify law enforcement if their firearm has been lost or stolen. According to ATF data, private individuals reported the loss of more than 173,000 guns nationwide in 2012, but researchers estimated that more than 500,000 firearms are lost or stolen from private residences each year. This discrepancy suggests that the majority of lost or stolen firearms may never be reported, significantly hindering law enforcement efforts to trace the source of these crime guns and to prevent weapons from falling into dangerous hands. This act would address this problem by requiring every person to report the loss or theft of firearms to local law enforcement within 5 days of the time the person discovered or reasonably should have discovered that his or her firearm was lost or stolen. Laws requiring the reporting of lost or stolen firearms have been enacted in 10 other states and in 14 local jurisdictions throughout California, including San Francisco, Sacramento, Oakland, and Los Angeles. These laws are useful to law enforcement for several reasons. First, when a crime gun is traced by law enforcement to the last purchaser of record, the owner may claim that the gun was lost or stolen to hide his or her involvement in the crime or in gun trafficking. Reporting laws provide an important tool for law enforcement to detect this behavior and charge criminals who engage in it. Individuals who repeatedly report their guns lost or stolen also put law enforcement on notice that they may be intentionally trafficking those firearms to prohibited persons. Second, reporting laws help disarm illegal gun owners. When a person who legally owned a gun falls into a prohibited category as a result of a domestic abuse restraining order or conviction, for instance, it is crucial that law enforcement remove the firearm from his or her possession as required by existing law. But when required to relinquish those firearms, a prohibited offender may falsely claim that his or her gun was previously lost or stolen. Mandatory reporting laws provide a check against that behavior. Third, the reporting requirement helps law enforcement track down missing guns and return them to lawful owners before they fall into dangerous hands. And finally, reporting laws make gun owners more accountable for their weapons and help protect rightful gun owners from unwarranted criminal accusations when a gun that was lost or stolen from them is later recovered at a crime scene.
Mr. Freelick.
Yes.
We probably misspoke. We have 45 minutes in total. We're now at the 30-minute mark, and I know the committee wants to ask some questions. So if you could.
Just very briefly.
Yes. And I don't want you to infringe on Mr. Willis's time either.
I appreciate that, sir. I'll just very briefly move on then to the Safety for All Act 6 policy reform would help correct a dangerous unintended consequence of Prop 47 by making clear that the theft of a firearm is a felony, regardless of the firearm's market value, and by making it illegal for individuals who are convicted of a misdemeanor instead of felony firearm theft as a result of Prop 47 to possess firearms for 10 years thereafter. I want to acknowledge and thank Vice Chair Melendez for your work to highlight the need for this fix. And finally, the Safety for All Act would ensure that the Department of Justice shares crucial data about dangerous individuals with the FBI's background check system database to codify current responsible best practices so that future leaders in this state will continue as a matter of law to sustain effective background check procedures and systems at the state and federal level. And thank you for your time.
Mr. Willis.
Thank you and good morning. Thank you for letting us participate. I wanted to just speak very briefly about some of the costs and savings associated with this initiative. When the Lieutenant Governor and the Law Center were drafting this measure, they had three overarching goals that I think we've accomplished. The first is to reduce gun violence in a meaningful way with provisions that work, practical ways of those working. The second is that those provisions should be very cost effective so that the burden on the state or local law enforcement should be minimal or reimbursed. And then the third is that, of course, that these provisions should have minimal intrusion on lawful gun owners, and that was a very important aspect of this drafting. We think we have met all three of those concerns because most of these provisions, the vast majority of them, get to and focus on taking guns and ammunition out of the hands of criminals and convicted felons. That is the point of this measure in large part. And the provisions are targeted in that way. I want to respond or discuss briefly some of the analysis that Ms. Lee brought to, or talk about some of the cost aspects of Ms. Lee's presentation. But before I do, I just wanted to remind us all that in addition to the costs associated with these provisions, we can't lose sight of the savings that occur with even a slight reduction in gun violence. And those are hard to quantify, and so oftentimes they are forgotten, but they are no less important. In fact, I believe they're more important. Even small reductions in gun violence can have tremendous cost savings at the state, local, and of course societal level. There are kind of two aspects of those costs or savings that occur. Not only does a small reduction or large reduction in gun violence make our communities much safer and better places to live, but they also save the state and local entities quite a bit. If you think about any crime scene or any accident scene, there are direct costs associated with every gunshot wound, with every murder or suicide. There's obviously the victims of those shots. They have to be rushed to the hospital. Their direct responder costs and healthcare costs. There's been, in 2010, a report suggested that, a report analyzed that there was a cost of $400,000 per firearm fatality in law enforcement costs alone. So that's an incarceration cost. If you have a criminal
The cost alone is $400,000. You also have investigations and then the incarcerations we discussed. Again, in a 2010 study, the study revealed that there were costs of about $87 million per year related to firearm assaults. And again, both of these studies don't even discuss the significant costs that occur with suicides or accidents. These are just crimes. Then you have, of course, indirect costs associated with gun violence, and those go on for years and years after a suicide or an accident or a crime. And that includes ongoing health care provision for victims. It includes lost productivity in people's lives and in their ability to work. It includes lost income taxes and revenue to the state for people that cannot actively participate in work. The Center for Disease Control in 2013 determined that in California alone, that loss of productivity as a result of gun deaths or injuries amounted to a loss of $4.24 billion to the state economy alone. So there are tremendous savings to be had, even with slight reductions in gun violence, and we often lose sight of those. Now I want to address the cost to the consumer, to the gun owner, lawful gun owner, who will be getting be authorized for ammunition, and also talk a little bit about the costs associated with each of these programs. With respect to the cost to a consumer for now complying with if this becomes law, complying with the authorization, the ammunition purchase authorization, it's a one-time fee over 4 years, as Ari said, that maxes out at $50 over 4 years. So that's $12.50 a year. That is 4 times less than an annual fishing license or a basic hunting license in the state. So the cost is very minimal. And in terms of and then, of course, once you are authorized, there are no point-of-sale costs associated with that. That is a one-time fee up front that you can get 6 months before this law takes effect. So there should be no problem with a consumer wanting to buy ammunition. There should be no delay at all. What does that $50 fee get the consumer, and what does it get the state? Well, it gets you the best of both worlds. It gets you a point of sale that is instant. If the consumer comes in and they are the seller looks at determines whether they are authorized or not. If they are, they look at a list on the computer. If they are authorized, they instantly receive their ammunition and they leave the store. There is no waiting period like guns. It's instantaneous. So that's easy for the consumer. And at the same time, it's a list that is updated in real time. So it's not static. It's not like a license that maybe someone was authorized 2 or 3 years before. This is a list that constantly is updated depending on whether someone becomes prohibited or not. So it's the best of both worlds. You have an active list of people that are authorized and taken on and off that list on a daily basis, and it's an instantaneous transaction for the consumer. Finally, I just wanted to talk about the cost associated with this, and there were some questions from the committee to Ms. Lee about that. We feel very strongly that the ammunition purchase authorization program, we looked at this very carefully. We discussed it with a number of stakeholders, including law enforcement, including after we filed with the Bureau of Firearms, and we believe very strongly that this, under just about any model that you look at, will pay for itself. And we even were so confident in that when we initially filed, we said $50 over 2 years, maybe we need to have it 2 years. We looked at that some more during the period by which you can amend, and we became convinced after talking to the Bureau of Firearms and others that a fee of $50 every 4 years would pay for this program. And again, as we mentioned, there is a startup period that gives the DOJ a number of years to get their systems in place. There is a $25 million loan that is available to get the database is in place. And we are, after all, talking about a system that the DOJ is very familiar with. Essentially, we are mimicking the instant background check, or the background checks that occur with guns. And as a result, they are very familiar with that process. And most of the expenses associated with this program, after you spend the initial money for the information technology systems, is hiring analysts who can process the background checks associated with the authorization form. And that's no different than a gun check. And so the DOJ is very familiar with that. They have that system in place. 25 analysts handled 1 million background checks in 2014. No matter how you look at these numbers that we're talking about, whether you have a lot of gun owners that want an authorization form or a smaller percentage, we think that there is more than enough in this fee to pay for itself and to be flexible, because at the end of the day, you're talking about most of the expense is associated with hiring analysts to process background checks, and those costs can obviously go up and down based on workload. And as a result, we believe that this program will pay for itself. We would be happy to answer any questions about the costs, but I think, Julie, you wanted to.
We're done. So we're going to have you stay until the committee can ask questions. But we want to get the opponents in because we have about an hour left, and we want to make sure they get their testimony in. And if you could stick around so we can ask questions afterwards, would be great.
Thank you very much.
Okay. So could we have
Yeah.
after we hear from the opponents, I want to make sure we get everybody's statements in.
Okay. Yeah, please come forward, and it actually was a little less. It was 40 minutes. So we'll do 40 minutes for the opponents. We need to hear comments from the public, and then the committee will have questions based on everything we've heard. But we do need to adjourn at about noon. So we hope you've divided up your time. You can go in any order you wish and take as much time as you wish.
Within that period of time.
Within that period of time. Yes.
Good morning, Madam Chair and members of the Senate and Assembly. My name is Michelle Hannessy. I'm a felony prosecutor in Los Angeles County. I'm also the president of the Association of Deputy District Attorneys for Los Angeles County. And I'm here to express both my professional and personal concerns about this initiative. Let me preface my comments by saying I have seen more gun violence than you can possibly imagine. I've tried over 40 murder trials, all but 2 of which included the use of guns. I've seen dozens and dozens of corpses. I've hugged the mothers of murder victims. And I agree that criminals and felons should not have guns or ammunition. Yet I still oppose this initiative on many of the points included in the initiative. As a prosecutor, my concerns are threefold, and the first 2 are specific to the proposed addition of Penal Code Section 29810. First, it places additional burdens on an already overburdened court system for every felony conviction and also for some qualifying misdemeanor convictions. The initiative will require an additional probation report to be prepared, at least 1, if not multiple, additional hearings after conviction, and in many cases, additional investigation and the preparation of a search warrant, as well as the execution of a search warrant, which is a process which requires a lot of resources and manpower, and all by the probation department, which is ill-equipped to handle this workload. My second concern is with the same section, the proposed Section 29810, which is also very likely unconstitutional, as it requires a judge to order a probation officer to conduct a search of private property for firearms if the judge has probable cause to believe that firearms have not been surrendered. Judges should not independently be forming probable cause and ordering search warrants. That is not the way it's done under our Constitution. It totally violates their function as neutral gatekeepers to direct the issuance of a search warrant. The Fourth Amendment talks about probable cause supported by oath or affirmation, and that probable cause and that oath or affirmation are supposed to come from law enforcement and then be screened by a judge, not the reverse. My third concern is on the outright ban of magazines over 10 rounds and the restrictions on ammunition transfers. And the problem with that is that, it's a very honest statement and it might be offensive, but no one will obey those laws. Otherwise, law-abiding citizens have not obeyed similar laws in California. When the city of Los Angeles issued a total prohibition on large capacity magazines, my understanding is not a single magazine was surrendered. It's bad public policy to enact laws that otherwise law-abiding citizens will ignore. It engenders contempt for government and for law enforcement. And finally, on a more personal note, as a gun owner, as a woman who lives alone, who also happens to prosecute violent criminals and gang members, I have personal concerns about the initiative. I appreciate that Lieutenant Governor Newsom thinks I'm a good enough shot to disable criminals who break in my home at night with only 10 rounds in my magazine. But I think that puts me at an unnecessary disadvantage when I'm trying to defend my life in a panic situation against potentially multiple assailants who may also be armed. And that's the problem, is this initiative in every way puts law-abiding citizens, law-abiding gun owners at a disadvantage without doing anything to actually prevent the criminal use of handguns. It's already illegal to shoot people with guns. It's illegal to kill people with guns. If those laws don't stop criminals, some additional infractions and misdemeanors certainly are not going to help. So those are just a few of the reasons that I oppose this initiative. I thank you for your time, and I'd be happy to answer any questions. And I am able to address Senator Leno's questions about normal practices regarding surrender of firearms by prohibited persons.
Thank you, Ms. Hennessy. Salcedo.
Mr. Chair, Madam Chair, thank you very much. Corey Salzillo here on behalf of the California State Sheriff's Association. We are also in opposition to this measure. California, as you know, has some of the strictest gun laws in the nation, and yet gun violence caused by criminals, gang members, and others who are prohibited from purchasing firearms continues every day, as Ms. Hennessy spoke about. California sheriffs are supportive of efforts to enforce the numerous laws that are already on the books against those who would use firearms against our citizens. We're supportive of domestic violence restraining orders. We've supported existing background checks and the waiting periods for purchases of firearms. We've supported bills to restore the prison felony, like AB 1869 by Assemblymember Melendez, to restore the prison felony for theft of a firearm that was taken away by Prop 47. But other than that provision that's included in this measure, the initiative that's being discussed today and will likely be put to the voters will do very little to prevent criminals from acquiring firearms and ammunition via the black market or through theft. Instead, what the measure does is it places additional restrictions on otherwise law-abiding citizens who wish to purchase ammunition for sporting or hunting use, who retain guns and magazines that are currently illegal and that we're told that they would be legal, and to pass historical or family heirloom guns down to next generations. The measure has a particularly unfair impact on collectors of historical firearms, pre-1945 manufactured high-capacity magazines that were previously grandfathered in, which are virtually never used in the commission of crimes, get wrapped up into this measure. And even then, the possession of magazines that were acquired recently under legal premises would be banned, and current owners would now have to turn them in, sell them, or remove them from the state. And the failure to do so would be an infraction or a misdemeanor. It would be unlawful to buy ammunition on behalf of other persons who aren't immediate family members. So a group of hunters, despite what the proponent said, for example, who purchased a large cache of ammunition for everybody in the group, would be breaking the law, as would anybody who acquires that ammunition from someone who says, hey, well, I'll go get the ammunition, you can reimburse me. That's unlawful under this measure. It would be unlawful to go out of state to buy ammunition and return to California with it. So not just the nefarious notion of going across the border to Nevada to acquire ammunition that you can't legally purchase here or that you couldn't legally import, but something as innocuous as going on a hunting trip out of state, acquiring ammunition lawfully, and then attempting to bring back any unused ammunition. That would be a crime under this measure. First offense is only an infraction, but a subsequent would be a misdemeanor. These are just a few of the new laws that would be created by this measure that peace officers would be required to enforce if it's enacted. Effectively, the measure creates a new class of criminals out of those who already comply with existing law and practice and have no intent to otherwise violate the law or perpetrate violence against citizens. Law enforcement agencies will have to undertake new training, new policies and procedures given the significant law changes that are contemplated here. Magazines that were formerly legal to possess will be illegal. Ammunition transactions will be scrutinized, and resources will be used to enforce a set of laws that criminals will simply ignore. The focus of efforts to reduce gun violence should be on those that are responsible for the violence and not those who have no intent to do harm. Thank you very much.
Thank you.
Good morning. My name is Joseph Silvoso. I'm an attorney with the law firm of Michelle & Associates. I'm here on behalf of the Coalition for Civil Liberties. And I knew if I have a hard time getting that out, that would be my biggest hurdle for today. The Coalition for Civil Liberties. Our coalition enjoys the support of law enforcement agencies, the district attorneys, as well as law-abiding citizens throughout the state of California. Our numbers grow daily in response to this initiative. The coalition also enjoys the support of the National Rifle Association, the California Rifle and Pistol Association, and Gun Owners of California. What we have here, and I hear the phrase a lot, and what is often touted with laws like these is, these are common sense gun laws. And that always gives me pause, because shouldn't we be talking about common sense laws? Why are laws that we're putting here forth today making criminals out of California citizens, causing a number of them to criminal prosecution, adding additional burdens on our business owners, and last but not least, creating a regulatory scheme which will cause tens of millions of dollars? That's just some of the issues that we'll be addressing here today. But unfortunately for this initiative, it creates more questions than it answers. To start from the beginning of the initiative, we're first going to talk about the theft loss reporting, which a number of you know very, very well because we've seen it many, many times before. And in fact, our biggest proponent, and let me quote directly here, the proponents urge that this law will improve identification of gun traffickers and help law enforcement disarm people prohibited from possessing firearms. I'm not convinced. For the most part, responsible people report the loss or theft of a firearm, and irresponsible people do not. I am skeptical but that this bill would change those behaviors. That's not me saying this. That's not people from the NRA or CRPA saying this. This is our governor saying this when he vetoed a similar theft loss reporting bill a number of years ago. And another bill came before him, and he didn't sign that one as well. We're again here doing the same thing all over again. And somebody please remind me of the definition of insanity, because here we sit again. And here's the concern and the underlying concern with this law. You have victims of crimes, people whose homes have been burglarized. And if they don't report their firearms lost or stolen within 5 days, you're making them criminals as well? Where is the logic in that? Why are we making the victims of thefts criminals themselves? Why are we putting law enforcement in the position to decide whether or not to cite an individual for an infraction because they didn't get to the law enforcement agency in time to report their firearm lost or stolen? As the governor points out, responsible people will do this. Why are we making this a crime? And moving on to the next portion of the bill that's somewhat concerning in our minds is the large capacity magazine ban. Keeping in mind that California, since January 1st, 2000, has prohibited the importation, the manufacture, keeping, offering, disposing for sale, the giving and lending of large capacity magazines, virtually limiting any legal way a person can own and acquire these magazines without certain exceptions allotted for law enforcement and certain permittees. Individuals who own and possess these magazines today have been law-abiding people. They've been law-abiding people and possess these magazines since January 1st, 2000. For 16 years, they've been law-abiding members of our communities. They've been using the magazines for purposes of going to the range, for recreational shooting. Why are we making their lawful possession, despite the fact that they've done nothing wrong, they've done nothing to incur this confiscation, why are we forcing them to take the magazines out of the state, turn them into a dealer, or surrender them to law enforcement? The concern I have with this goes to my day job as a criminal defense attorney. I would really hope that the members and the citizens of this state are as well understanding and know California gun laws as well as I do. I've co-authored a book on the subject. It's 300 pages long. And it's not 300 pages long because I like to write. It's 300 pages long because that's how many laws our members and our citizens have to get through in order to lawfully possess firearms and the things that go along with them, transporting them, using them recreationally. The saddest conversations I have to have with my client is when I sit across from them and I have to explain them their misunderstanding of the laws. And it happens all the time. And to use a prime example, the ban on assault weapons goes back to 1991. I am still advising clients who are facing very real felony charges that they're facing a substantial restriction on their rights, substantial costs associated with a conviction, and a lifelong conviction on their record because they were unaware. They didn't know that this law has been on the books for almost now 25 years, actually more than that for some of them. And so now we're dealing with another set of laws, and I'm certain if these laws were to pass, I will be sitting across from a table from another person being prosecuted for these laws, or for a violation of these laws, for magazines they've possessed for 20, 30, 40 years. And it's not the people who have extenuated rap sheets that go on for pages and pages. It's a person who for the first time has had to talk to me, the first time has to talk to an attorney to guide them through the criminal process. And while the violation is punishable as a misdemeanor or an infraction, unfortunately, when given the option, a lot of our prosecutors will choose to prosecute these violations as misdemeanors. Moving on, there's been a number of comments concerning the ammunition restrictions and requirements. And am I wrong? Did the LCAV just propose instant background checks for firearms? I thought that might be what they were proposing and saying that's possible to do for ammunition, but I might have been mistaken. But nevertheless, if we're requiring background checks, and if background checks are the so-called silver bullet when it comes to preventing gun crime, well, there shouldn't be any more gun crime, because under California law, there's no way to transfer, acquire, register a firearm in a person's name without a background check. You can't come into the state with a firearm for purposes of moving here and living here without registering that firearm with the state. It's a background check. You can't give a firearm to Senator Hancock. If I wanted to give you a firearm, and if you wanted to purchase a firearm from me, I couldn't give you one. You and I would have to go down to a licensed firearm dealer, and there would be a background check. If my father wanted to give me one of his firearms, I'd be able to acquire directly from him, but I'd also have to report that firearm to the California Department of Justice, and there's a background check. If background check is the thing that's going to prevent these things from happening, well, why hasn't it already? And in reading through this and knowing, I'd say a bit about California gun laws and how they work, The thing that struck out to me, again, for purposes of the ammunition restriction, is that I don't think it's entirely clear that the proponents of these laws understand exactly how firearm owners acquire or possess or be compliant with California laws, because ammunition is typically and sometimes often purchased in bulk. I've done it myself. And the way I've gone about it is I get a couple friends together and say, hey, I'm going to be purchasing 1,000 rounds of ammunition. I don't need 1,000 rounds of ammunition, and it's kind of expensive. So why don't we split the costs up? Well, if I'm splitting that between one friend of mine, that's 500 rounds. Not only if he were to purchase that ammunition directly from me, would we both be violating the law, but I would then be considered an ammunition vendor for some weird reason, and I would be violation of the law for lack of a license as well. I don't know why the line was drawn at 500. It doesn't make any sense to me. But nevertheless, that would be the line I'd be crossing, and therefore I would be subject to criminal prosecution for a violation of this section twice. And now, Mr. Cork pointed out some rather significant concerns when it comes to the costs associated with this initiative, and herein is where we find the first of what I'd consider some substantial concerns as it relates to costs. Because in order to enact this ammunition legislation, you're going to be creating not one but two potentially very large databases that are going to, at least one, well, both, will be requiring constant upkeep and oversight by the California Department of Justice. And Senator Hancock, I know you've been monitoring the APPS program and the costs associated with that, and I've been watching from my desk in the office when you've been having those hearings. And your concerns relating to that process and the costs involved rear their ugly heads in this situation as well, because first we're going to have one database that's going to track all of the ammunition purchases. It's akin to the automated firearms system, at least that's what I believe the intent of the author is when they created it. However, when a person purchases a firearm, they may just purchase one firearm. That's, I guess, their choice. But nevertheless, over the years, they will purchase countless thousands of rounds of ammunition, potentially. Each one of those transactions will be an entry into that system. And soon that system will balloon, exponentially so, because as people add to it, they're going to need to add more transactions and more transactions and more transactions to what usually remains a very limited number of firearms that are entered in their name in the AFS. And so those firearms transactions will be entered in over and over again, and soon we'll have millions of transactions that won't be of benefit to law enforcement, because here's the other problem. With ammunition, ammunition is usable. It goes away after you use it. The automated firearm system, the person has the firearm registered to them. You can reasonably and potentially expect them to still possess that firearm. If a person goes to the gun store, purchases the round of ammunition, which gets sent up to DOJ, and then goes shoots that round of ammunition that afternoon, why are we keeping a backlog of all of these transactions over what appears to be an indefinite period of time? This system is going to expand immensely. And the other database system is for the background checks. And we've heard the testimony before about the $50 to pay for the 4-year permit. The problem here is that first DOJ is going to be required to conduct a background check on the individual. That's going to be the first time when the person applies for the permit. However, we're then going to be talking about continuously updating and oversight of that database, because the database will need to, and the initiative requires, that the database of ammunition permittees, it requires them to be updated prior to them attempting to purchase the ammunition. And so what we have here currently with apps will be mirrored with the ammunition purchaser database in that it will require constant oversight, it will require constant upkeep, and it will constantly require DOJ to make determinations about who's eligible and who is not. And here's where the question, where the costs come in, because now I've talked about two rather huge databases that presumably are going to be reimbursed by a $50 fee that a person pays once over a 4-year period. The initiative asks for $25 million. I unfortunately think that it's far more likely that this legislature will probably be having hearings concerning more money and DOJ asking for more versus that fund and that loan of $25 million will be repaid. And I did have another question when LCAV was concerned and saying that the total costs attributed to gun owners would just be that. I guess it broke down to $12 a year, because I think they're failing to take into account all the costs that are now going to be incurred by the vendors or the dealers in that ammunition, because the added background checks, the added employees, the addition of the certificate of eligibility requirement for all of the employees will not just be absorbed by the dealer, but nevertheless will be attributed and transferred over to the firearm purchaser. And so when they tell you, oh, don't worry, it's just going to cost you $50, I have some concerns with that. And then last but not least, having to deal with the felon turn-in, as I like to call it, or the requirements that a convicted person turn in their firearms. Again, while in theory, I think it has and potentially has some merit, but in execution, it's flawed 5 ways to Sunday. When a person enters a plea for a conviction or enters into a plea agreement with the district attorney's office, that plea and conviction is happening right then and there, that day. However, we're now creating a mechanism and a procedure in which a person will enter their plea, and instead of having the case over and done with right then and there, you're requiring that the court and now probation conduct additional work in association with the turn-in and the forfeiture of these firearms. And I mentioned probation because probation will have the lion's shares of work in this situation, because the person convicted will have to fill out a report, potentially in violation of their Fifth Amendment rights, is stating where and how many firearms they have. That report gets turned over to probation that does a check of the automated firearm system. Probation will have to, and in a very limited period of time, make a determination whether or not that person who, once they turn in their firearms, has complied with all of the requirements set forth in this initiative. I know probation very well. They look after and are looking after some of my clients right now. But nevertheless, they are extremely overworked, they are understaffed, and this initiative will swamp them with additional research, paperwork, and reports they will have to write in order to advise the court of whether or not the defendant has complied with all of his or her requirements. And again, that gets us back to the court. The court's going to have separate hearings for purposes of whether or not that person has made the determination, has turned in the firearms as required. The additional costs, we have serious concerns, will not be recouped when it comes to these requirements. And last but not least, I don't think it's going to do anything to advance the concerns set forth in the initiative. Again, we're talking about, and we always hear the phrase common sense. I'm having a very hard time finding the common sense here. If mental health is a concern, why aren't we addressing the mental health concerns? Why aren't we giving more money instead of the $25 million to be thrown away in needless databases to the hospitals, or removing the stigma attached to mental health? If we're concerned about youths getting access to firearms, why aren't we attempting to educate the members in our schools instead of making firearms a suspendable, or discussing firearms a suspendable offense. I see Mr. Sawyer.
Well,
wanting to move on.
Using up Mr. DeLuz's time unless he wants to cede it over to you.
Oh, no. and I was summing up. Mr. Lewis, please.
Craig DeLuz. I'm here with the Firearms Policy Coalition, which also represents the Cal Guns Foundation, the California Association of Federal Firearms Licensees, and the FPC Second Amendment Foundation. I've been before both bodies in the Senate and the Assembly numerous times, and you know, my natural inclination as a legislative advocate is to read a bill, analyze it, and in cases of these anti-gun measures, tell you what's wrong with them. I think the real advantage I have here today is that I don't have to do that. I don't have to do that because you've already seen these measures. Just about every single thing that is in this initiative has been proposed to this body, has come before this legislature, has gone to this governor, and have failed, have been deemed to be too extreme or unworkable within the state of California. Now, we're talking about a state legislature that has passed the most aggressive gun laws in the country. We're talking about a governor who is probably one of the most liberal executives in the entire nation. He signed into law 29 anti-gun bills or anti-Second Amendment measures. And so I'm figuring that this body and the governor, I'm figuring you're not in the pocket of the gun lobby. It may be a stretch, but I'm figuring that's the case. So I'm assuming that if these measures, if all of these measures that are in here have been found to be problematic here, then I'm wondering why it is that we're taking, once again, another look at them, if this is another way to get into the process. You know, one of the biggest challenges with the initiative process is that it is very difficult for the individual, the average citizen, to get into and be able to make really substantive, informed decisions about some of the easiest topics. But when we start getting into some of the minutia that's related to firearms, when we start talking about, you know, the technology relating to firearms, we start talking about the firearms industry and what is required of those who are involved in it as consumers, those who are involved in it as vendors, and all of the compliance that goes into it. To be able to make an informed decision is a very, very difficult thing on an initiative where chances are you're going to get maybe one mailer mixed in with a whole bunch of others, as well as see some very, very, how shall we say, inflammatory campaign commercials probably on both sides. The fact is here in the state of California, I've heard a number of members here and your staff talk about reasonable gun laws. The big challenge that we have here is at a certain point, you go beyond reason. When you are going to create a law that even those who are tasked with enforcing the law are telling you is going to be unenforceable, that is going to encourage individual citizens to ignore. To me, that is the very definition of unreasonable. In the city of Los Angeles or in any of the cities in which standard capacity magazine bans have been put in place, how many magazines have been turned in? I have yet to hear of one. And I think that is the thing that we have to look at is, are we going so far in the state of California, have we gone so far beyond reason that now we're going to make criminals of law-abiding citizens? You know, the representative from the Center to Prevent Gun Violence, anyway, one of the proponents of the measure had come forth and, you know, discuss kind of the history of gun control. You know, in California, the history of gun control goes much further back. It started in the 1800s, and it's largely about always keeping, quote unquote, those people from owning firearms. In the 1800s, it was Native Americans and Chinese immigrants. In the 19th century, it was black radicals and the Black Panther Party. Well, today we're looking at instituting gun laws that restrict the rights of all law-abiding citizens. And that's really what it's about. I think it's been shared before that not one of these measures is going to keep someone who is dead set on breaking the law from actually violating the law. This is a measure that is so egregious that historically law enforcement has either been supportive of such restrictions or they've been silent on such restrictions. And yet here they sit telling you that these measures, that the measures that are in this bill do not make sense and go too far. You know, one can only rationalize that the whole point of this practice is for one thing. It's for one individual to be able to get his name in the paper so that he can run for higher office, because at this point his sole job is to wake up in the morning and determine whether or not the governor is still alive. That is an abuse of this process. And I think it is a slap in the face to every single one of you who've spent hours, and when I say hours every day, sitting and listening and analyzing and discussing each and every one of these topics in and of themselves. We may not necessarily agree on the positions, but at least I know that you've taken the opportunity to inform yourself. That when we have these discussions with you and with your staff, that we know we're talking about substantive policy issues. I am offended that this measure has come forth. I'm offended because its desire to circumvent the process for political gain is an assault on everything that when we talk about our representative democracy. I want to thank you. I know this has been a long process, and I would just want to make sure on behalf of everyone here to thank you for taking the time to not just listen to the proponents, but to also listen to us. Thank you.
So we'll now move to comments from the public. If people wouldn't, we're going to ask people to take 1 minute. How many comments from the public are there? Well, okay, 1 minute, because we need to have time for questions from the committee. And you can speak right from the podium or the microphone behind?
It's your house.
Okay, you can speak right there. I do want to say one thing, though, and that would be to Mr. DeLuce, and that is I do take offense at the personal attack on the proponents of the initiative. The initiative process is there so that when the government does not act, the legislature doesn't act, it can be taken directly to the people. We know there are a number of cumbersome things about the initiative process. It's harder to change. We prefer to do legislation. We know the impact of money and organization and politics and the constraining effect it often has. We try to balance those things. And to attribute motivation to somebody who isn't in the room is something that I think we should not do in this process. So, having said that, welcome to the committee.
Thank you, ladies and gentlemen. My name is Nikki Stallard, and I'm here for California Pink Pistols. We are an LBGT self-defense group. I come here to speak against this initiative. The biggest thing that our group does is, of course, we teach firearms safety training, and this initiative would basically mean that we'd have to shut down our pink pistols. And not only do we reach LBGT, but because we are a non-traditional firearms groups, we reach many other people, women, minorities. They come to us because, you know, we're not the knuckle draggers. Certainly I believe in firearms safety. Certainly we believe in that firearms crimes are a serious problem and stuff, but you know, we're dealing with a constitutional right, and while I believe we have constitutional rights, we do have responsibilities, and this initiative, I would just like to see that the legislature actually sits down, both sides, we sit down, because the problem isn't law-abiding citizens, the problem is criminals, and we should focus on criminal misuse of firearms and put the hammer down. I know that crime disproportionately affects the Afro-American community. Certainly there's many things we could fix. Our failed drug policies, our economic policies, which destroy the economy, destroy the hope, the inner cities. People have lost hope, no purpose, they've lost their dreams. That's what we should do. Fix people's hopes, dreams, fix their families. Crime will go down. Thank you.
Chairman, Chairwoman of the committee, Sam Paredes representing Gun Owners of California, and I was just checking my knuckles to see if I'm one of those knuckle draggers. But, you know, I grew up in East Los Angeles, Mexican descent. I've been representing Gun Owners of California and working for them for a very long time. I just want to bring out a couple of points that I think will respond to some of the inquiries that were made by members of the committee. Number one, there are about 2,600 licensed dealers in the state of California. It is not a stretch or a secret or anything that they sell the vast majority of all ammunition throughout the state of California. They will not be paying any fees into the dealer authorization fund because they are grandfathered in by this initiative. So that fund is not going to get any sort of real revenue in order to develop that database. Certainly not through fees. Certainly those dealers who sell ammunition to some of the poorest communities in California, Walmart being one, where you can buy ammunition at a reasonable cost, they will not be able to comply with this and therefore deny many low-income people the ability to affordably avail themselves of ammunition. The last thing I want to point out was something that was brought up by the proponents of this legislation, where they discussed about the cost of the victims of gun violence. There are some statistics that have been quantified and used by the FBI and the federal government to point out that well over 2 million times a year, law-abiding citizens use guns to successfully defend themselves. That means they were not victims. California is 10 to 20% of everything that happens in the country. So if you just take 100,000 or 200,000 times a year, the law-abiding citizens use firearms to protect themselves, and you do anything that makes it more difficult to avail themselves of guns or ammunition or magazines, there will be more deaths, and they will be victims. Thank you very much for your time.
Thank you.
Madam Chair. Chairman, thank you. Roy Griffith, I'm speaking on behalf of the California Rifle and Pistol Association and as myself as a sportsman, conservationist of the state, and also as a retired peace officer of 32 years of service to the state and protecting our peoples and our resources. This initiative would do nothing but impact the law-abiding citizen, the sportsman, the conservationist, the sports shooter, the person just out trying to enjoy firearms in a legal and lawful manner. It's not going to affect criminals. Criminals are going to continue to be criminals, and criminals are going to continue to break the law and circumvent this bill and other laws already in place to protect life and property. Thank you very much.
Thank you. Good.
Hello there, Mr. Chair, members of the committee. Mark Henley with California Waterfowl Association. Our association's primary concern with this measure is it's going to be a major disincentive for the public to participate in hunting. Hunting is already very well regulated. In order to get your hunting license, you have to take a mandatory safety course and pass a test. Hunting is also very expensive. There's costs associated with accessing land. You have to buy stamps and tags. You have to buy equipment. These costs can run into the thousands of dollars every year. This measure, by adding more costs and bureaucratic red tape, is only going to be a further disincentive for people to hunt. We know from hunter surveys that both cost and regulations are barriers to hunting. Another thing to note is because this measure effectively bans mail order and internet sale of ammunition, there's going to be fewer pieces of ammunition purchased. The problem with that is there's a tax placed on that goes directly for wildlife conservation purposes. It's called the Pittman-Robertson Act. It's a very important funding source for our Department of Fish and Wildlife, helps them to manage their lands. There's going to be less revenue to go around because of this measure. This measure also impacts nonprofit conservation groups as well, particularly, again, with costs and red tape. That also, at the end of the day, is going to mean less funding on the ground for wildlife conservation purposes. So, thank you.
Thank you.
Good morning, Mr. Chair, members of the committee. My name is Josh Bronis. I'm here on behalf of the Altausher Conservation Coalition and on behalf of our 30-member organizations representing unions, agriculture, outdoors, and conservation organizations. We're emphatically opposed to this measure. It's incredibly costly, cumbersome, burdensome, and misguided, and will not serve the purpose that the proponents promote. As someone who did their master's thesis on the mitigation of active shooter threats, I can tell you emphatically that the research and the data indicates with all certainty that neither the availability of ammunition nor the capacity of magazines has any bearing on either the threat of active shooters nor in the number of casualties that they cause, but it's more about the differentiator between those that carry firearms illegally into those areas where firearms are not allowed to be carried legally. Thank you.
Thank you.
Members of the committee, my name is Bill Gaines. I'm with Gaines and Associates, and I'm here today representing a variety of wildlife conservation and hunting organizations. California, as you heard many, many times today, has the most aggressive gun laws in the country. Only law-abiding citizens comply with those gun laws. This initiative, if approved by the voters, will add a myriad of additional laws to the books, which again, only law-abiding citizens will comply with. Criminals are criminals because they're not afraid to be involved in crimes. Law-abiding citizens don't shoot people, they don't murder people, they don't use guns in the act of violence. Criminals do. Criminals will not comply with this act, but the law-abiding citizens, of course, will. In short, it'll have no impact on gun violence in our state. I'd like to close by reading a letter that was shared with me by a very dear friend of mine who's deep into his 90s, who fought in the Battle of the Bulge in World War II and who was wounded. He shared with me a letter that he sent to the legislature when I told him about this initiative. I'll read a couple of excerpts from it. As a hunter of game birds since 1938, I shall be adversely affected by this initiative's restrictions and requirements. I shall find it much more difficult to protect my property, in particular my home, against criminal behavior should this act be approved. I have been trained in the safe use of firearms by my father and by the U.S. Army during World War II, wherein the wound I sustained was provided by the enemy rather than by friendly fire, and I am upset to be treated as a potential bad guy under this initiative. Finally, the Second Amendment to the U.S. Constitution permits me to bear arms in the defense of my country, which I have done. Should the act be approved, I fear the arms I shall bear in the defense of my property will no longer be firearms. I adjure you to disapprove Lieutenant Governor Newsom's proposed Safety for All Act of 2016. Thank you.
You do get a scrape.
Thank you very much for letting me speak. I'm just a concerned citizen, not with any organization, and I'm just very concerned that the idea of this initiative is to end all gun stores, just as a similar ordinance did in San Francisco. It's a great San Francisco Chronicle article in October of last year about how similar regulations on ammo requirements led to the closing of the last gun store there. And I believe that goes at the heart of the intent of the proponents of the initiative. It seems less about stopping gun violence as just ending guns. And I don't believe there is a correlation with gun ownership and violence. And we often hear the point of industrialized nations. But if we look at the UN's data on guns and homicide, and we compare nation by nation, if you look at United States, and you don't count any of the gun homicides, just take them at their word, all the gun homicides will magically disappear if we get rid of the guns. You look at our non-gun homicides, that's still higher per capita than almost every nation in Europe when you count their gun homicides and regular homicides. Furthermore,
1 minute.
Excuse me?
Close, wrap up. We only have 1 minute.
I apologize. I just would like to emphasize that it's the 4 states with the lowest homicide rates in the country are shall issue or no permit at all, which means that, like in Vermont, second lowest, you don't need a permit. You can be 16 years old, carry a gun. Second lowest homicide rate in the country. It's not access to guns that's the problem. It's another issue, and by focusing on this, we're not addressing the root causes. Thank you.
Thank you.
Good morning.
My name is Kevin Vella, and I am here representing the California State Chapter of the National Wild Turkey Federation. Our organization's primary concerns with this initiative is that it will make criminals out of currently law-abiding sportsmen. We're also concerned that this initiative will negatively impact Pittman-Robertson funds, which fuel wildlife conservation projects, as well as fund state and federal wildlife agencies. Thank you very much.
Thank you. And you have the last minute, sir.
Thank you, Mr. Chairman, members of the committee. Thank you for taking the time today to go over this. Ed Worley with the National Rifle Association. I won't belabor the point of what you've heard today already, but one thing I will point out that was not pointed out by any of the proponents or opponents is the ballot measure is so poorly drafted that law enforcement rank and file are not exempt. Law enforcement rank and file will have to get a license to purchase ammunition, or they will have to go to the police chief or sheriff to get a written letter of approval every time they want to buy ammo for purchase for training. I, as a law enforcement instructor, can tell you that would be extremely problematic for the tens of thousands of peace officers up and down the state. So imagine in a sheriff's department with 5,000 members that the only way they're going to be exempt from this licensing requirement to purchase ammo is every one of those persons in that department is going to have to go to the sheriff every time they want to buy ammunition and get a letter from the sheriff asking for an exemption from the licensing requirement. So the thing I find fascinating in this whole discussion here is this ballot measure is so poorly drafted that they don't even trust law enforcement rank and file to buy ammunition without a license. Thank you very much for your time.
Thank you.
Thank you. Good. Well, we're ready to move on to questions and comments from members of the committee. So if the opponents and proponents would like to come back up, I think it would be interesting to, we have about 10 minutes.
Don't fight.
Yeah, to,
Short.
yeah. So my co-chair says questions and answers short, please. And I know you've been waiting, Ms. Melendez, so why don't you start off?
Thank you, Madam Chairwoman. I wish I had chosen to spoke in the beginning, perhaps out of turn, so that I got the same and equal amount of time that other members of this committee were given. However, since we only have 10 minutes, I do have some questions of the supporters of this initiative, who I assume helped draft the language. Is that correct? Yes, okay. Oh, I'm sorry. This is awkward, isn't it, with your back to me? Okay, and I just want to comment that while the chairwoman has expressed her displeasure with one of the people giving testimony and calling out Lieutenant Governor Newsom specifically in his purpose for this initiative, I am equally offended that the person who came up with the idea for this initiative isn't here today to address this body. I think that's incredibly disrespectful. Be that as it may. So I'm reading the language here, and we are clearly opposed in our views on this, but that's okay. The intent, the statement of purpose and intent is to keep guns and ammunition out of the hands of convicted felons and other persons who are prohibited by law from possessing firearms and ammunition. And I assume that is to cut down on gun violence, correct? Okay, so, and we had a lot of discussion about, and heartbreaking, frankly, discussion about people who have been murdered by guns and personal experiences. The one thing we have not talked about today, though, is the fact that the majority of gun deaths in California are by suicide. I Googled last night, it didn't take me very long. I have 4 different news articles here from 4 major publications, and they all say the same thing, that suicide by gun has gone up, murder by gun has gone down significantly, not by a little, by a lot. 2/3 of gun deaths are by suicide. Not by a crazed felon shooting up a school, not by someone who is a prohibited person who managed to get their hands on a gun. These are suicides. And they weren't suicides done by a high-capacity rifle. So I'm confused about what effect exactly this initiative is going to have. MSNBC, as well as Pew Research, state that gun violence has dropped 56% in the last decade. Despite the fact that in California, the number of people who have purchased a gun or own guns has increased significantly from about 615,000 to about 915,000 now. So a lot more people have guns in California, yet the violence has gone down. The number of murders has gone down. The number of suicides has gone up. So I think the gaping hole in this discussion we're having is we are not talking about the big elephant in the room, which is that we have a suicide problem in California. We don't have the epidemic that has been suggested today, that we have too many people with guns who are shooting innocent people. The SAC-B, most California gun deaths are suicides. Gun-related homicides have declined sharply over the last 2 decades. SAC-B again, suicide is now the most prevalent cause of death in California, resulting from the misuse of a firearm. The number of gun-related murders has fallen sharply in California in the last decade. Newsweek. Virginia Tech, Sandy Hook, Fort Hood, Binghamton, and Washington Navy Yard resulted in 101 deaths combined. 101 deaths combined in all those tragedies. In 2012, 32,288 people died from gunshot wounds in the United States. 64% of those were suicides. This is, I share the concern that I don't want innocent people killed by a gun. I don't want to be sitting at the hair salon, at the dentist, or wherever, and have someone come in and just start shooting. No, nobody wants that. But this initiative, in the clear intent, is not going to solve the problem that some are claiming exists. And could you please comment on the fact that suicide is actually, the biggest problem we have related to gun death, more so than somebody going into a school and shooting someone? Thank you.
I'd be happy to respond to that question. You are right that suicide is the major problem when it comes to gun violence, and that this initiative is not necessarily directed at suicide. It is directed at taking guns away from criminals and from ensuring that criminals do not buy ammunition. I personally have some experience with suicide. Sadly, my nephew committed suicide with a gun a year ago. He was not a prohibited person. He was just a guy who was experiencing some severe stress in his life and hadn't slept for a few days, and had guns because he thought they would be necessary to protect his family. Instead, as is so often the case, he ended up using the gun on himself in a moment of desperation. You're also correct that gun violence has dropped by 56% nationwide, but gun violence has dropped twice as fast here in California in the last 20 years, and that is due in large part, because of the 50 strong gun laws that the legislature has adopted in that time period.
Okay, then we agree. Gun violence has gone down in California significantly because of the laws that are already in place. So my question to you then is it your intent to reduce gun violence to zero? Because that's not going to happen. So if we've already reduced it by more than half, and the number of suicides have gone up, the number of murders have gone down, what are you trying to do here?
The numbers are still unacceptably high, even though they have gone down. Too many people are dying from gun-related injuries. So, no law is a panacea. No group of laws is a panacea. We are not saying that if Californians go to the ballot in November and vote for this law and it passes, that our gun violence problem will disappear. You're right, that's not going to happen, but we must try. We must try to do something.
Okay, and I agree with you, but this isn't going to solve the problem. I mean, and one of the opponents brought up a very good point in that if I purchase a gun and that stays with me, I don't get rid of it, I don't sell it, I don't destroy it, but I keep purchasing ammunition for that gun, which is going to go into this database that has been proposed. So over time, then it starts to look like I'm stockpiling ammunition, and then what happens? I mean, is that, I don't think that that's your intent. I get that, I understand your intent. I don't agree with it. I understand your intent, but I think you're creating another problem within this process for people like me or anyone else who's just an average, gun-owning person. And
Is that your?
I don't want to, I don't want to take up all the time, but I just want to make sure that this is on the record, that I don't believe that this initiative is going to solve the problem of gun violence that some have suggested we have. I think we have more of a mental health issue that we need to discuss more so than an ammunition problem. Thank you, Mr. Chair.
Thank you for your brief and concise question. Anyone else have any?
I'm happy to address this to either opponents or proponents. In states that have stronger gun safety laws, do we see any correlation with reduced use of firearms in suicides?
Yes. In a word, yes. My background is in suicide policy in the VA and in the veterans community, and the data is out there that non-firearm suicides are roughly equal across 50 states. About the 10 states with the highest rates of firearm ownership and easiest access to firearms by mentally ill individuals have about twice the rate of firearm suicide, and as a result, significantly larger suicide problems.
Please.
I think also if you would. Are we on? Okay. Actually, if you look at Australia, which has essentially owned private handgun ownership, if you look at, they just hit a 10-year high in their suicide rates. And they've banned guns dating back, I mean, we're talking decades. So the issue is, and I think that this is what the Assemblyman was bringing up, we're focusing in a lot of these laws, in this case, on the tools. The fact is yes, we have a suicide problem. Yes, we have a violence problem. And our focus is, and the focus of this legislation is, let's focus on the tool of that violence, and let's not instead of focusing on the cause of that violence.
Mr. Chair, if I might.
Yes.
Mr. Freilich, if there's a response to the comment with regard to Australia, if you have any information.
I'm not familiar with the data about Australia. I just know about the United States' data, but I can share that we have a different view. We don't think it's an either or. If we wanted to address drunk driving, we wouldn't just address a problem with alcohol or the root causes of alcoholism. We would also pass laws to make drunk driving behavior illegal. And that's what we're trying to, you define responsible behavior by enacting laws. Thank
you. Mr. Glazer, you had a question?
I would just ask either the proponents or the opponents if they have any data on how many of these ammunition clips exceeding 10 rounds are in circulation in California.
I could respond to that. We don't. That's part of the problem. As Mr. Freilich noted previously, large capacity ammunition magazines don't contain serial numbers or any identifying marks, so there's no way to grandfather them in, even if we wanted to, the way assault weapons were grandfathered in. So nobody knows. And that's why the LA example isn't very persuasive either, because we don't know how many people in LA had these magazines to begin with. Also because they don't have to just turn them into law enforcement. They could have sold them to a firearms dealer or removed them from the state. Why? So we do not know what's happened in LA after the local law was passed.
There you go. And I think more to the point is we don't know how many people in lawful possession of those magazines right now either. How many people we're talking about who've had these for all this time, who have possessed them legally, who have used them for recreational purposes. How many people are those who are going to be affected by this versus what we're trying to do here and what we're trying to stop?
I think it's also important to note that, it was recommended by the proponents that they could sell it to a firearms dealer. There is no market for used standard capacity magazines in a state where the dealer can't sell them. There is no market. Who's the dealer then going to turn around and sell them to? Why would they purchase them if they have no ability to sell them?
Okay, thank you. You have questions?
Thank you. Yeah, I do. I'm just interested in the confiscation issue that was raised, or the taking issue. And what Mr. DeLuce just said made me think that there may not be a monetary value to these things. How do you take some, you can regulate something. I just wondered if there's any case law on the takings issue.
First, with the idea that the government is confiscating people's magazines or taking them, that's just not the case. They aren't being taken because people do have the option of taking them out of the state or of selling them to a firearms dealer. I don't know what the fair market value of a magazine is, but it does retain some economic value. But moreover, the government is actually allowed to take or to confiscate property where that property threatens public safety. There's a distinction between cases where a government regulation is intended to protect the public versus the situation where the government is actually acquiring property for its own use. For example, when the government takes somebody's home and has to pay that person because they're putting a freeway through the person's yard. Those are completely different situations. So there is technically there is legally no taking under this scenario.
Do you know what the status is? I believe that both Sunnyvale and San Francisco enacted prohibitions on high-capacity magazines. Are those cases in the court right now?
The Ninth Circuit did consider a challenge to the Sunnyvale law, and it upheld the law. It said that it did not violate the Second Amendment, and that as the Heller Court, the Supreme Court determined in 2008, the Second Amendment guarantees the right of law-abiding, responsible individuals to possess a handgun in the home for self-defense. You do not have to have a magazine capable of holding 100 rounds of ammunition to defend yourself in the home. So the court held that it was a valid law and rejected the Second Amendment challenge.
If I might note, we keep using the terms high-capacity magazine. The reality is in most cases, what we're talking about are standard capacity magazines that are issued with these firearms, ranging between 15 to 30 rounds. The example of the 100 drum or the 100 round magazine, first of all, is the exception for anybody purchasing magazines, and would probably be in a small minority of those high capacity magazines that are actually in existence in the state of California.
Yes, the 10 round is not an industry standard. There's no agreement that this was going to be the amount. This was arbitrarily determined by this legislature back when this was decided. If it was 9, if it was 12, 10 is a nice round number, and that's appears to be what they stuck with, but for no other reason. The underlying concern is, of course, then you have people in lawful possession with these, and they continue to be in lawful possession well until we decide to change the laws. And then those lawful owners then all of a sudden become criminals and subject to prosecution.
Again, just a question on that. Is there a capacity after which you would consider something a high-capacity magazine that has no hunting purpose or home protection purpose? And I'm just thinking that I believe it was a 34-round capacity magazine that killed all the people in San Bernardino. Would you agree that that's high capacity? Maybe 10 was the wrong number? What's the feeling?
I think you're trying to limit to the point where what is capacity and what is going to be an actual standard capacity or whatever's preferred capacity for an individual is really going to be up to that individual's interests, what their desires are, and what their needs are. I may not need a 10-round magazine to defend myself. Someone who has a difficult time loading and unloading ammunition into a firearm may need something bigger, depending on whether or not there's an issue with concerning age or in frailty and their ability to change magazines. And so what you're essentially asking me is how can I, for everybody out there who needs to make an individual decision of what capacity magazine, what they potentially may need for themselves, what that capacity should be. And I'm sorry, Senator, I can't do that.
Okay, thank you. So there is no definition except one that we arbitrarily take. Okay, thank you. Just another, this is to both the proponents and opponents. I tried to follow the statistics. I find them very interesting. I don't think I was able to do that with all the different statistics that came out. I think if any of you just have a sheet with what the statistics are, handguns, homicides, suicides. I'm interested also in the statistics with other states and nations in terms of what we mean when we say there's an epidemic of gun violence in this country as opposed to other countries. I would just welcome any of your statistics if you can give them to me to share with the committee. I do want to just briefly comment that one thing that struck me in the conversation is, you know, if we're talking about creating a new class of criminals, that's kind of what the Public Safety Committee does a lot. We try to either cut back on penalties on the theory that we have public health issues connected with drug use and other things that may make it not appropriate for a criminal sentence. And we're often told not to do that because laws have a deterrent effect that's important. Sentence enhancements, all those things come to us for that reason. I think the suggestion that we have mental health issues connected with these things, and there could be other approaches, is an interesting one. And I think we're all trying to find a balance between the deterrent effect of laws for law-abiding people and public health, mental health issues connected with harm that's done to people. So I look forward to continuing that discussion with everybody here, regardless of the outcome of the initiatives or the legislation that's pending. And just to say that, you know, a number of senators did go to Norway last year. In Norway, they have very few gun laws and very little gun violence. They also have a prison system based on rehabilitation, not punishment. And they have a 20% recidivism rate as opposed to ours 60% plus. So there are probably many things we can learn and possibly do together in this, regardless of what happens with this particular initiative or legislation. But I thank you all very much for coming, and I think we've learned a lot. And if you could submit some of your information to us, we could go over it and probably learn a lot more.
I just want to echo everything the chair of public safety on the Senate side said. And I will tell you, I've been here 3 years, almost 4, and I've heard this discussion about mental health, and I've not seen really any legislation on both the opponent or the proponent side to really deal with that. And I think this legislature should really delve into it seriously, even if I have to write some legislation to actually get the ball rolling, because you're absolutely right. We need to do something about the mental health of people who have possession of guns, and we need to stop talking about it and start doing something. And so I'll push that. As far as what we have on the table and what we're discussing now, it's just interesting to me that we not only have an initiative, but I think we have, I'll call them companion legislation, because I don't want to couch one is better than the other, whether it's looking at ammunition sales, ammunition regulation, but we also have the De Leon bill, which also looks at that. Whether you're looking at lost and stolen guns, I believe AB's 1695 Bonta bill. We also have a Jackson bill that also addresses it. And I think they're not opposed to one another, but they may have also helped strengthen it, or may even make it a better solution for what we ultimately want to do. And so we will be having, obviously within the legislature, some discussions on how we can move all of this forward, including the gun theft laws and even the ghost guns and bullet button, is to have a comprehensive discussion on what really makes sense moving forward. Obviously, getting cooperation for all branches. That's not only the Senate, the Assembly, but even the governor, to have those discussions so that we come up with something that we all believe is the best way moving forward. And so it was really important for me to get information today because it'll help me formulate how we move forward on the legislative side. Obviously, the initiative side will move independent of us, but it'll be interesting to see how we can hopefully marry it a lot better so that we can move forward. So I also want to thank everyone for coming here today. Is there any other? That's it.
The hearing is adjourned.